The General Laws and Technology Committee will come to order. Could you call the roll?
Senator Vogel, are you here?
Yes.
Wait.
Senator Vogel votes aye. Thank you.
Where do I?
Just going to give the senators a moment to log in. And then just open it up. If I may, Senator.
All right. It says I need to enter a code. What's that? Now that I figured out that I actually am here, we do have a quorum, so. All right, let's just take care of a couple of housekeeping things. There is one bill to be referred to the Committee on Commerce and Labor, and that is Senate Bill 1419 from Senator Marsden. All right, there's a motion and a second. Any discussion on that? All in favor of the motion to re-refer that bill to Commerce and Labor, please record your votes on the screen. We do have Senator Vogel.
Senator Vogel votes aye.
All right. That motion carries 14-0. All right, and we have 4 bills that I know of that we will pass by for the day. Those are Senate Bill 1198 from Senator Peterson, Senate Bill 1222 from Senator DeSteff, Senate Bill 1268 from Senator Deeds, and Senate Bill 1410 from Senator Bell. All right, there's a motion and a second, and I think we can just do this by a voice vote. So all in favor of passing by those 4 for the day, say aye. Aye. All opposed, no. All right, those are done. All right, could someone bring in Senator Suderline? All right, Senator Suderline, Senate Bill 1103.
Thank you, Mr. Chairman. Senate Bill 1103 is identical to a bill that this committee reported to the full Senate, and which the full Senate passed with a supermajority vote during the special session. It provides that the individual votes of members on the Virginia Parole Board will be public, and it does that through making them subject to the Freedom of Information Act. Every other board that we've looked into in the Commonwealth, their votes are public. The Parole Board was the one exception. Last year we found out that they weren't keeping minutes. That distressed some folks, but honestly, minutes aren't that important if they don't contain any actual information. And so this bill seeks to add important transparency of having these votes public, just like the votes that we take here.
All right. Are there any questions that anyone has? Senator Eben, you wanted to?
Yes, Mr. Chairman.
Yes.
A few questions for the patron. First, I would ask the patron if he's aware. It's my understanding that the parole board doesn't vote in a group, rather that, I don't even know how many members there are, if there are 5 members or something, but if there are 5 members, if 3 members vote no, then the remaining 2 members wouldn't vote, that they vote individually offline, not in a central meeting. Is that correct?
That's what I was told. Of course, we don't get to observe those
Okay.
proceedings, and also, since the votes aren't public record now, I have no way of verifying that, but that's what I've been told.
Does this bill cause for all of the information that they get about the person's behavioral evaluations and other prison records of their behavior and progress, would those also be made public under this bill?
No, Mr. Chairman. I would tell the senator that what this makes public are the votes, just in the same way that the city council votes, those are public, but the justification for each one of those votes is not, and that's the same way it is with pretty much every other recorded vote that I'm aware of in the Commonwealth.
Okay. Thank you, Mr. Chairman. Thank you,
All right.
Senator.
Is there anyone else who has questions or comments?
Mr. Chairman.
Yes, Senator McPike.
Thank you, Mr. Chairman. Just a question to the patron. I think we asked this question during special session last time, which is how many other states require the release of their parole boards' public member votes? Or how many do not?
Thank you,
Senator
Mr. Chairman. I believe that the Roanoke Times highlighted that it's something that's common throughout. I don't have the exact number. That votes being public is not unusual. And I would again point out that I used to say almost every board and council in Virginia has public votes, but I stopped saying it because I've yet to find one that's not. This is the only exception I found. And it's also an outlier even in the criminal justice system. When a defendant faces charges, of course they get to know who accused them. That's a constitutional right. The name of the prosecutor is public. The name of the judge that presides over the case is public. And sometimes that comes up when we consider their reelection, how they've done in certain cases if they resulted in jerk complaints. Also, when the case goes to appeal, the names of all the judges and their findings of those cases, and if they uphold the verdicts, is all public. And then the only place it's not public is the parole board.
Mr. Chairman, I think the committee is familiar with most boards or others requiring, this is sort of a specialty case that my recollection was the last time we had people testify that there was some level of concerns in terms of safety of members due to the nature. I mean, they're making decisions on people's freedoms, and sometimes family members or others get fairly heated about that. So the answer is we don't know which states currently exclude and which states provide that information. We don't have that data, even though we addressed this months ago.
If you'd like to go by temporarily, I'm happy to step out.
Maybe one of the callers or those signed up that may be on to testify would provide some information to the subcommittee, the committee. Thank you.
All right. Well, it's your call as to whether you would like to have it go by for the day, or else we could proceed.
I'm happy to proceed.
Okay.
I'm happy to get him that information on the floor because I remember it being the subject of the article.
All right, that sounds fine. All right, are there any other comments or questions from members of the committee? All right, anything further you wish to say, Senator Suderline?
I hope that you will report favorably.
Okay. All right, is there a motion?
Mr. Chairman?
Yes. We have a motion to report. Is there a second?
Was there any comment from the public?
Are there any public comments on this one? Okay.
Mr. Chairman,
Apologize, but yes.
could we go ahead and get rid of the vote so we could, because if there are people, I know we'd like to hear them. I know there's a motion on the table, but love to hear from the public if there are any.
Love to hear what?
Public comments.
Yeah, that's what we're checking out here, so.
Muriel Branch, please go ahead.
Muriel
I'm
Branch?
sorry, I raised my hand for the wrong bill.
Okay,
I will be speaking on SB 1318.
all right,
Megan Ryan, please go ahead.
Megan Ryan. All right, could you bring Megan Ryan on if she wishes to speak?
Hi, thank you, Mr. Chair. I'm Megan Ryan with the Virginia Coalition for Open Government. And I would first like to, if I may, address Senator McPike's question. I was unaware that there was a request to compile data from other states, but I just, this information is available on a website called the Reporters Committee for Freedom of the Press Open Government Guide. And, I just picked up, I just started, I while you all were talking, I just typed it in real quick. And, first one that came up was Alabama. And it said that the parole boards have to follow all public meeting requirements. So I can look through that and I'm happy to work with Senator Suderline to try to compile that information for you. I would like to support this bill. We think that it, like other state commissions and boards in Virginia that make decisions impacting citizens both directly and indirectly, should be publicly available and by name. Now, I know it's been said that the parole board will be members will be put at risk because of their votes. But this argument to me is a red herring because the members themselves are already publicly known. So we know who these 5 people are. So whether they become targets from a particular vote is no more or no less from being a target just from being on the board in the first place. But more than that, there are a multitude of public bodies and officials, from the governor to you as members of the General Assembly, from state and local judges, prosecutors, local boards, and mayors who make unpopular decisions that some will feel threaten their safety or their rights. And the parole board is no different. So making a parole board member stand by their votes is not novel and it's not burdensome. It's just a basic measure of oversight and accountability. And we urge you to vote by name in favor of this bill. Thank you.
All right. Is there anyone else to speak?
That's a good line.
Amy Seibert, please go ahead.
Hi, good afternoon, Mr. Chairman, members of the committee. I will be very brief. I will associate my remarks with Megan Ryan. I'm here on behalf of the Virginia Press Association, and we support this bill as well. We also believe that, as all other public bodies of Virginia, these votes should be made public. So we appreciate that, and we hope this bill will report out of committee just like it did in special session. Thank you.
All right, so Amy Seibert has testified in favor of this as well. Anybody else that we have?
Yes, I'm Benjamin Knotts. I'm with Americans for Prosperity. We've been advocating for parole reform and an objective process. We believe transparency should be a part of that, so we support the bill.
All right.
And Chai Love.
Hi, my name is Shai Love, and I am coming to you on behalf of the Black Coalition of Change. We definitely support this bill. There needs to be more transparency when it comes to our governing bodies and our justice system. Also, I have a question. I wanted to know how long have you all been in this current meeting?
Just a few minutes, so this is the first bill we've taken up.
Okay, because there's a few of us and we've been all waiting since 12:30.
Sorry about that, so we'll have to try to we set it up so the schedule for this, the scheduled start of this was half an hour after we finished our floor session, and we finished at about 1:40, so we got started about 2:10.
No problem. Thank you very much. We're committed to the process, so it's okay.
Apparently so. So if you're hung around
Yeah.
for that long, so yeah. All right. Is there anyone else to testify? Yeah. All right. So we have a motion that has been made to report the bill, and it's been seconded. Any further discussion? All right. Yes. And this actually will need to go to the Finance and Appropriations Committee if it's. Okay.
To approve and refer to the Committee on Finance.
All right. All right. We have the motion to report and re-refer to Finance. All right. If there's is there any other questions or comments? All right. Let's vote on the board. No.
Senator Vogel, how do you vote?
Senator Vogel votes aye.
Ayes 10, nays 4.
All right. Ayes 10, nays 4. This passed, and it will go to the Senate Finance and Appropriations Committee now. So.
Thank you, Mr. Chairman and the committee. I appreciate it.
Certainly. All right. Next, we have Senator Cosgrove. He's out there, right? Yes, Senator Cosgrove. Come on in.
Thank you, Mr. Chairman.
Certainly.
Mr. Chairman, I am carrying Senate Bill 1424 at the request of the Human Directors Association. Excuse me, sir, microphone. Oh, I'm so sorry. Like to. There it goes. I got it. Can you hear me? Yes. All right. Thank you. Mr. Chairman, I'm carrying Senate Bill 1424 for the Virginia Funeral Directors Association. This is a fairly simple bill. It defines a manager of record as a person who defines and handles all operations of licensed funeral service establishment and sets out conditions under which a funeral service licensee or a funeral director may serve as a manager of record. The bill requires that the funeral service have establishments employing a full-time manager of record. And Mr. Chairman, I believe there are some amendments that are offered.
All right. Do we have amendments?
Mr. Chairman, yes, I have one line amendment to the bill that I just clicked on to send over, so it should show up on LIS now, but I can read the line amendment. On line 38, after establishment, period, strike the remainder of line 38, all of line 39, and through establishment, period, on line 40, and insert any funeral licensee may serve as a manager of record for any funeral service establishment. Any funeral director who was issued a license prior to December 31st, 1979, and has maintained that license in good standing may serve as manager of record for a funeral service establishment.
Mr. Chairman, that is correct, and I agree to that. It's both on line 39 and 40.
Senator Cosgrove, could you just speak closer to the mic or make sure it's on?
I'm so sorry. Yes, of course. There you go.
That's better.
Okay.
This
amendment was asked for by the Funeral Directors Association, and General Legislative Services has put that forth, and I am in total agreement with it.
All right. Is there a motion on the amendment?
Move the amendment.
All right. Okay. The motion and a second. Is there any discussion on the amendment? All in favor say aye. Aye. All opposed, no. All right. The amendment is adopted. So.
Thank you, Mr. Chairman. Basically, this bill, as I said before, defines the manager of record for a funeral manager. I believe the change was required due to the licensing that happened in 1979. So as amended, this bill requires the funeral service establishments to employ a full-time manager of record. And it has been agreed to by all three of the funeral manager associations.
All right. All right, are there any questions of the patron?
Mr. Chair,
Yes.
a question for the patron.
Yes, ma'am.
Senator Cosgrove, I was trying to follow the amendment, but even with the amendment, is it true that the manager of record would still be someone who has to be proficient in the embalming process? Is that correct? Did I hear that correctly?
Yes, ma'am, and they would have to have been licensed, sorry, I'm on a mask. They would have to have been licensed in 1979, which requires that.
Thank you, Senator. The main concern I have is communities that I represent. Within the Muslim community, the embalming process is actually considered to be against sacred tradition.
Yes.
And it is prohibited to embalm the body. And therefore, it would be quite a challenge for Muslim communities, individuals of that faith who want to bury their family members, their loved ones, to have to go through a funeral home that requires the embalming situation. And so that's a serious concern for me with this bill.
Mr. Chairman.
Yes.
Yes, ma'am, I would agree with you on that. I believe that was not contemplated when this bill was drafted by the Funeral Directors Association. Also, Jewish families require that a body be buried within actually 1 day, not 3 days, like most. So I am open to any amendments that may come through this to deal with religious requirements.
Well, first, I think that, I'm sorry, I think Senator Boysko was probably in the queue before me, and then Senator Ruff and Bell, sorry.
I think Senator Ruff was in front of me.
Mr. Chairman.
Thank you, Mr. Chairman. Senator Cosgrove, I have had communications from several nursing homes, funeral homes that are in opposition to this bill. Do you know why they're in opposition?
Senator Ruff, Mr. Chairman, Senator Ruff, no, I have not heard any opposition sent to my office or to me personally on this bill.
Mr. Chairman.
Yes, Senator Ruff.
The three organizations that you mentioned, how widespread are they in their membership?
Mr. Chairman, Senator Ruff, they are the largest funeral association directors. Funeral Directors Association. I have not heard any opposition to this bill at all up until what you just told me.
Thank you.
And Mr. Chairman, just in consideration of the members, if you would like me to take this by and see if I can amend it to find out what's going on, I have no problem with doing that. I certainly don't want to offend any religious community with a bill that's brought to me by the Funeral Directors Association.
All right. Does anyone want to make a motion to pass this bill by for the day?
Second.
Are the people who oppose the bill able to speak against it? I got notes that the Funeral Consumers Alliance and 19 funeral homes and the SCI, Virginia Funeral Services, were opposed, but I'm assuming they're queued up to speak, no? Are they here today? I mean, maybe they're not here today. I just...
Opposed to the bill, please raise your hand.
We have one.
Larry Spiaggi, please go ahead. You're muted. Please unmute yourself.
Sorry, not opposed, but I just wanted to clarify one thing real quick. There is verbiage in there for religious exemptions or for firms that are not embalming. So funeral homes, there's crematory services, there's green funeral homes that do not provide embalming, and they would be allowed to have a funeral director only, not an embalmer. So there is wording in the bill that clarifies that very, very well. We took that in consideration after Senator McPike last year when we split the license up. For years, we've had one license that was a funeral director and embalmer. Now we have a funeral director, embalmer, and a funeral director embalmer combination. But as you read the bill, it does have an exemption in there. If you have an establishment that does not offer or has a charge for embalming on their general price list, and a general price list is required by the Federal Trade Commission for every funeral home to have and make available to consumers as they request it. Thank you.
Scott Johnson, please go ahead.
Thank you, Mr. Chairman. It's Scott Johnson. I represent SCI Funeral Services of Virginia. I emailed Senator Cosgrove's office on January 17th to advise that our 50-plus facilities and cemeteries around the entire state were opposed to this, and I got a confirmation back from his office that they would let him know. So if that didn't occur, it wasn't any part of me not doing that. We are opposed to this legislation. We think it unfairly restricts what you did last year. You passed Senator McPike's bill last year, 1044, passed the Senate unanimously. That was a jobs bill to create the ability and direct the funeral director board to promulgate regulations for funeral director only license. They did that. Those regulations have been in effect about 2 weeks, maybe 3. We don't know any evidence of any problem with a funeral director only serving as a manager of record. To Senator Hashmi's question, a funeral director only doesn't have to be trained in embalming. So for the faith concerns that she has, what you passed last year fixed it.
Right.
This bill is trying to handcuff it. This bill is not coming from the funeral director board. It's coming from associations. There's not uniformity in the system. This is a way to try to protect the old status quo, the old Virginia. What you did last year and what you passed is trying to create jobs for a population that has funeral directors that are getting older, aging out, and also to meet market demands because we see more customers want to have cremation and not be embalmed. We would ask respectfully that you PBI the bill. Thank you.
All right.
Mr. Chairman, and Scott's a friend and been a friend for many years. I did not see the email, so I'm not trying to mislead you on that. It's certainly up to the will of the committee, what they want to do on this bill. I was just asked to carry it on behalf of the Funeral Directors Association. If you would like to take it by, I'll see if I can fix it. If not, then it's up to the will of the committee.
All right.
And I would ask Senator McPike if he sees an issue in this.
Right.
Mr. Chairman?
All right. Yes, Senator McPike.
Yeah, I mean, I understand the context of why the bill comes in. I think some of the folks have articulated it, which is the board did separate the embalmer and funeral director to deal with the religious issue last year through the regulatory process. And so there is my sense in some parts of the funeral directors community still want the funeral director that also is skilled in embalming to be the person of record. And so the policy question before the committee is, we essentially have two sets of universes, those funeral directors who do not require embalming due to religious purpose to also be the manager of record, and then a subset that have a funeral director with embalming qualifications also being, versus do you just allow funeral directors as a whole policy then becoming the manager of record? And I think that's the challenge, I think, that was articulated by some of those in opposition is whether or not you have a workforce that is willing to do the embalming and go through the skills and requirement and training to achieve that, and then to also build up to be the funeral director at the same time. And so that's, I think, in the industry, some of the debate that I've observed over the last year of whether the additional requirement should be required on those that also offer the embalming services. And so that's sort of the underlying policy question before the committee.
Mr. Chairman,
Yes.
if I might, I'm a little taken aback because I had not seen Mr. Johnson's email. May I take this by for the day? If it does not agree with Senator McPike and Senator Hashmi's initiatives, then I will ask to strike the bill.
Okay. What's that?
I will ask to strike the bill if it doesn't meet the committee's
All right.
requirements.
Does anyone want to make a motion to pass it by for the day?
Mr. Chairman, I move that we pass it by as the patron has requested. I think it's fair to give him that opportunity to go through these things.
Second.
All right, there's a motion and a second to pass it by for the day. Any discussion on that? All in favor say aye. All opposed, no. All right, thank you.
Mr. Chairman and Senator Bill, thank you so much. I'll try to get this right or it'll go away.
Okay, all right, one way or the other. Okay, thanks. All right, is there anyone else out there with a bill?
Mr. Chairman, I have one if you want me to do that.
There's no one out there? All right. Yes, Senator Bell.
Mr. Chairman, this bill is SB 1279. The other bill I had, actually, we passed it by for the day. This bill is a fairly simple bill. It clarifies the scope of transition services provided by the Virginia Department of Veterans Services Administration bill. They have a Virginia Transition Assistance Program that helps transitioning service members, veterans, and spouses, which is also usually difficult for them to transition out of the military. Wanting military people to stay here, having a good transition is important. What this really does, it defines the services that DVS to assist military service members, veterans, and their spouses. Currently, spouses are not eligible for these services. And obviously, employment for spouses is very important. Similar to the V3 program, they provide a range of services to veterans and their families. The Code of Virginia does not currently define the scope of DVS service, and this really defines transition services. And the agency will be able to enhance existing services, better assist its assistance to transitioning service members, veterans, and their families. To let you know, we've actually had over 67,000 veterans hired to date. So it's a very successful program, and by allowing them this leeway, I think it'll do even more good. I think we have some people on the line to talk about it. There was Fiscal Impact came back, said there was no budget amendment necessary on it. I submitted one just in case, but with that, Mr. Chairman, I'm happy to answer any questions, and I do think we might have people in the queue.
All right.
Mr. Chairman.
Senator Mason.
Senator Bell, I'm sorry if you addressed this at the beginning, I missed it. So this is the transition assistance program that we've been doing, augmenting the Virginia Values Veterans Program, and we're just reading the work that's been done for a number of years into the code. Is that correct?
That's correct.
Awesome. Thank you, Mr. Chairman. It's a great program.
All right.
Mr. Chairman.
Yes,
Senator Reeves behind you. Mr. Chairman, I'd just like to speak to the bill as well and thank my co-chair for the caucus for carrying the bill. I can't thank this body enough for the amount of work that we've done, especially with regard to our veterans and the putting our money where our mouth is when it became to women's veterans. And this is just one other step to ensure that we remain the most veteran-friendly state in the union. And I'd ask to be the pleasure of the body or the committee to pass the bill.
Motion and a second. All right, and I'll all right. The motion is to report and re-refer to Finance and Appropriations. Any further comments?
Mr. Chairman, was there any
Yes.
public opportunity?
one here, okay.
Kathleen Jobs, please go ahead.
All right, you may proceed.
Yeah. Good afternoon. Thank you for the honor to be here. Deputy Secretary of Veterans and Defense Affairs, Kathleen Jabs, and we strongly support this bill. It's from our secretary.
Thank you. All right, was that it? All right.
Mr. Chairman?
Yeah.
Question. There is a FIS already out on this that said that there is no budget amendment necessary. It was preliminary. Is that the reason why it would be going to finance?
It's going to finance because finance asked for it.
Oh, okay. All right. I got a budget memo on it, but I was just wondering because there's no fiscal impact.
I think as, trying to be cautious, typically finance, when they first look at these bills, do ask for something that they think might have even a long-term thing, even if there's no short-term impact there. So, that's probably why they're looking at it. So
Keep an eye on it for us, Mr. Chairman.
okay, I will try. All right. If there's no other questions or comments anybody has, then we will proceed to the vote on the motion to report and re-refer to Finance and Appropriations.
Senator Vogel, how do you vote? Okay. Ayes 14, nays 0.
Okay. That passes 14-0. All right. Senator McPike, do you have a couple of bills?
Yeah, yes, Mr. Chairman.
All right.
Let's see, we have, in order, we have Senate Bill 1271. Yeah, Senate Bill 1271, Mr. Chairman and members of the committee, is the Freedom of Information Act that, in language that you're probably familiar with during special session that we passed due to dealing with meeting in electronic means during states of emergency. This is the language that was considered by the FOIA Council and the language that was approved through that committee that's now being carried forward to make in our permanent code sort of the procedures should continued states of emergency exist or other items such as this come up again.
All right. Are there any questions of the patron?
And I believe we have a few speakers that are also in the queue as well.
All right. If there are no questions, any comments from the committee? All right. Who do we have from the public to speak?
Amy Seibert, please go ahead.
All right, Amy Seibert.
Good afternoon, Mr. Chairman, members of the committee. Amy Perrin-Seibert here on behalf of a wide coalition of folks who worked on this bill since back during veto session when we had to amend the budget to allow for electronic meetings of public bodies. And so I just wanted to, in the interest of time, just list a few of the folks that we worked together on this issue for the last year. That would be NVTC, VRE, PRTC, NVTA, the Virginia Press Association, the Virginia Coalition for Open Government, VML, VACO, the City of Alexandria, Arlington County, Loudoun County, Falls Church, and Prince William County, and a number of our numerous other public bodies that we worked with. And so we are really appreciative of Senator McPike's work, as well as Delegate Sullivan's work on the House side, and the governor's office for putting this in the budget. It was hugely helpful. And it's really important because not only does it allow public bodies to meet in person, it also outlays how the public can interact, that they are able to comment and that they're able to participate themselves. So again, this is only for the duration of an emergency when it's unsafe to meet in person. And again, it's a may, not a shall. So it just allows people to be able to do this. So we hope it is the pleasure of the committee to pass this bill, and happy to answer any questions.
All right. Does anybody have any questions of Ms. Seibert? All right, thank you. Anybody else to testify?
Yes, Mr. Chair. Dan Holmes, you'll be next to speak. Just a reminder that if you'd like to speak, please raise your hand, but you can please go ahead.
All right. Dan Holmes, please.
Chairman, members of the committee, my name is Dan Holmes. I'm speaking on behalf of the Piedmont Environmental Council. First, I want to say I understand the need for continuity of government and the rationale rationale behind the bill, but I wanted to flag a few general process and transparency concerns from the larger conservation community that have been raised since the pandemic began. We're concerned about codifying continuity of government language for other types of more discrete emergencies. The provisions on public access to and participation during electronic meetings don't adequately address the needs of the public, failing to provide meaningful opportunities for engagement in the process. We would ask for consideration of additional safeguards that are not, as currently written, incorporated into the bill. And those would include at least 7 days notice of proposed actions on or agenda items, allowance for written comments in addition to electronic comments, the recording of meetings for later viewing, and a requirement that any action must be introduced at one meeting and voted on in the second, properly noticed meeting. The more we do to ensure that the process during emergencies contains reasonable safeguards providing the normal process, the better we can feel that we are providing the citizenry with not just the continuity of government, but the transparency and good governance practices they deserve. Thank you for your consideration.
All right, thank you.
Phyllis Erico, please go ahead.
Thank you, Mr. Chair, members of the committee. I'm Phyllis Erico with the Virginia Association of Counties, also speaking for the Virginia Municipal League today. We heartily support this bill. Working with local governments, it was really confusing at the beginning of the emergency to try to continue to conduct important governmental functions. I will say that this language was vetted over several meetings of the Freedom of Information Act Advisory Council with lots and lots of input from many stakeholders. And we ask that you do adopt this language and support this bill. Thank you.
All right. With that, no more? Okay, no more from public testimony. All right, wait a second. We do have Senator Boysko's listed here to speak.
Yes, thank you, Mr. Chairman. I just want to thank the patron for bringing this bill forward. I represent the town of Herndon and the town of Leesburg and have repeatedly been asked to make sure that this happens, and I just wanted to record my appreciation. Thank you.
All right.
And Mr. Chairman?
Yes, Senator McPike.
If I could just offer a comment to one of the speaker's comments. This law changes nothing in regards to all of our existing laws for public meeting notices. And in fact, this is very much discussed during the FOIA Council. The Virginia Press Association wouldn't have supported it had it changed somehow our public meeting notice requirements and public comment requirements. And so these are included as a part of that vetting through the FOIA Council. And a lot of the stakeholders were there at the table to ensure that that was still a maintained staple of our law, and it is included in this framework as well, Mr. Chairman. Thank you.
All right. Any other questions or comments? All right. Anyone want to make a motion? Report. We have a motion to report and second to that. Any further discussion? And I assume this one does not need to go to finance? Okay. All right. All right. Okay, we now will vote on the board on the motion to report the bill.
Senator Vogel, how do you vote?
Senator Vogel votes aye. Thank you.
Stewart votes aye by proxy.
Senator Stewart votes aye by proxy.
Yeah.
Ayes 15, noes 0.
All right, thank you.
I've been asked to remind senators to please also speak into the microphones. I want to make sure members of our staff and of the public can hear you.
Okay, thank you. All right.
John, you want me to take the second bill, Mr. Chair? Yep.
Who are here? Senator McClellan and then Senator Spruill. Go there.
Okay, I have Senate Bill 1360. Oh, sorry. So Senate Bill 1360 makes 3 changes to the Human Rights Act. And the first question I know you're going to ask is how this relates to the Virginia Values Act that we passed last year. And it does so in the following way. It provides a clear definition of workplace harassment. The Human Rights Act already prohibits workplace harassment, but it does not include a definition of what constitutes harassment. So what this bill does is, rather than creating new liability, it adds a definition of what the parameters of workplace harassment is, and that definition is based on both federal and state case law to date. This will provide more clarity for both employers and employees without them having to go search case law to determine whether they have grounds for a complaint with the Department of Human Rights. The bill also fixes a couple of holes and confusion that were created with last year's amendments to the Human Rights Act. First, it provides a statute of limitations for a complaint filed with the Division of Human Rights. There is no statute of limitations in the Human Rights Act, except for with pregnant worker discrimination on the basis of pregnancy. That statute of limitations is 2 years. That is also the statute of limitation for many tort claims. And so what this bill does is create a 2-year statute of limitation for filing a discrimination complaint with the Attorney General's office. The bill also provides a consistent employer size threshold across all Human Rights Act discrimination claims of 5 employees or more. This will eliminate confusion around the bifurcated employer size for different types of discrimination claims by having one threshold. Finally, the bill clarifies that if a judge decides to award attorney fees and costs, that costs means reasonable litigation expenses, so there's no confusion around what type of costs those are. This is a bill that has been worked through by a number of stakeholders over the past year, including the administration, the Attorney General's office, the Virginia AFL-CIO, the Virginia Domestic and Sexual Violence Action Alliance, the Virginia Employment Lawyers Association, the Virginia Interfaith Center for Public Policy, the Virginia Poverty Law Center, ACLU of Virginia, Birth and Color RVA, Equality Virginia, NARAL Pro-Choice Virginia, the National Women's Law Center, Planned Parenthood Advocates of Virginia, SEIU 512, and the YWCA Richmond. I think there are a number of people who signed up to testify, so we can either go to them or I can take your questions.
All right, does anybody have any questions of the patron?
Mr. Chairman.
Yes, Senator Mason.
Mr. Chairman, Senator McClellan and I were talking this morning because I didn't understand lines 25 through 28. And as we worked through what we were trying to get at and what it actually said, I think that the senator may have agreed that they weren't the same. And so I would ask Senator McClellan if she would consider it a friendly amendment if we would strike the new language after policies, starting with "the" on line 25 through the end of 28.
Mr. Chair, I don't know that I'll consider it friendly, but I understand the amendment, and it's not the end of the world. But I will say what we were trying to do in that language, and I understand based on my conversation with Senator Mason that this is not as clear as what we intended, is we were trying to make clear that because you have cases that you can file under both federal and state law, we wanted to make clear that this would not eliminate your federal claims and vice versa. But I understand that the way that this language is written, that is not clear, and I don't think it would harm the bill if it was taken out.
You don't think it would harm the bill if what?
If it was taken out.
So, Mr. Chairman, I'd move that moderately friendly amendment.
All right, we have a motion and a second to take out the last word on line 25 and all of 26 through 28. Is there any discussion on the motion? All right, all in favor of the motion, please say aye.
Aye.
All opposed, no? All right, we'll take that out. And
Mr.
that
Chairman?
actually caught my attention too, so.
Yeah, okay.
And it was because they shall not be used to limit the availability of remedies is sort of the language in there that sort of jumped out.
It's probably not necessary.
All right.
Mr. Chairman, may I ask one more?
Certainly.
There are two parts. Senator McClellan, a moment ago, when you talked about going from 15 to 5, you said you were standardizing or bringing it in line. And also the question going from 180 days to 2 years, are you also are you just trying to bring those numbers in line with other areas? Is that the reason for the change, ma'am?
Yes, so under the employer number threshold is different depending on whether it's unlawful discharge or another type of discrimination. And there's no rational basis for that. Either it's going to be a violation of the law or it's not.
Right.
And how many employees that you have shouldn't determine whether it's a violation just because someone is fired versus whether you've created a hostile workplace or you've sexually harassed someone. So that's why we want to provide that standard number of employees. On the statute of limitations, to be clear, the 180 days is not in code. It is in the regulations that have been adopted. But that is actually shorter than what the EEOC statute of limitations is under federal law. A federal claim, you have 300 days to file. But again, in Virginia, if the actions rise to the level of a tort, or if it is pregnancy discrimination, it is 2 years under Virginia law. If sexual harassment rose to the level of a crime, you would have 2 years to make that case. And I think the reason for the 2 years, 180 days is too short, particularly for sexual harassment, but not limited to that. You're talking about someone, if they have been fired or if they leave because the harassment is so bad, it's a hostile workplace, and they leave, you're going to be looking for a new job. You're probably more focused on that, and depending on the level of the harassment, sort of dealing with the trauma of that issue. But another thing that we've noticed that is sometimes, and this is particularly true in sexual harassment, you don't come forward right away because you don't want to be the only person to bring an allegation. But once somebody else does, or 2 or 3, then you start to say, okay, this wasn't just me, and maybe I need to come forward. We have seen that on the criminal side where people who were criminally sexually assaulted did not bring a case within the statute of limitations on something that happened when they were children. We ended up extending that statute of limitations last year for that very reason, and one of the testimonies we heard was about how when an incident happened to a young woman from her cheerleading coach, based on reactions that she and her family got when they started to talk about it, she chose not to come forward until she found out, a few years later, that there were other girls who had been assaulted. Now, again, that's on the criminal side, but it's the same concept, that sometimes you need a little more time to overcome the trauma and be prepared to come forward and file a claim. But again, making sure you have the same statute of limitations, whether it's pregnancy discrimination, sexual harassment, discrimination on the basis of race, is just logical, makes sense, and avoids confusion for both employees and employers.
Thank you, Mr. Chairman.
Any other questions? Okay, Senator Boysko, you're all set, okay.
Mr. Chairman,
Yes, Senator Reeves.
a question for the patron.
Yes.
I know this is hypothetical and I'm thinking in the weeds, but a long time ago, I was a young cadet at a public institution where under your bill, it wouldn't cut mustard because in building young officers, you're consistently, daily harassed to build a stress level in a young cadet to build them to be able to be a strategic leader for later and all these other things. Would you inadvertently wrap into some of these even in law enforcement, going through the training academies, they specifically stress you out and harass you to build that stress level up in order for you to be able to understand how to maintain control through critical incidences. I don't know how to do a carve-out for those things, but I think they would be included in this. And I don't know if there's legal counsel that could say they would be excluded in training and those sorts of things.
Let me respond. Because this is codifying what is already case law on what constitutes workplace harassment, this is not creating a brand new definition out of whole cloth. This is based on what is already case law. So if what you are describing is already covered under either federal anti-discrimination laws or our current Human Rights Act, that would already be illegal, and would be grounds for a complaint to the Division of Human Rights today. This bill doesn't change that.
Well, okay. Thank you, Mr. Chairman.
Can I add one more clarification for Senator Reeves? Can I add one more clarification for Senator Reeves? Yes. And just also, I wanted to make clear, this is harassment on the basis of a protected class. It is not general harassment.
Which is listed earlier up in the paragraph. Okay, I got it.
Andrea Johnson, please go ahead.
Good afternoon, Chair and committee members. Andrea Johnson from the National Women's Law Center. As has been said, the Virginia Human Rights Act already prohibits discrimination, but it doesn't include a definition of workplace harassment, which is a form of discrimination, and that leads to confusion for courts and employers as to what constitutes harassment and has led to varying interpretations. The definition that has been included in this bill and that we support strongly is pulled from the strongest elements of federal and state law and follows closely the remedial intent of those laws. But this definition avoids outdated and harmful interpretations from federal law, that making sure that they don't get brought into Virginia's new law. And these have been very narrow interpretations that are not responsive to the lived experiences of workers and workplace power dynamics, and that grossly minimize harassment, such that conduct that most people would find egregious is not considered unlawful. For example, a male coworker groping a female coworker's breast was found by a court to not be unlawful because it happened just once and thus wasn't severe or pervasive. These interpretations have also minimized the harassment experienced by women of color, but by encouraging courts to parse apart and isolate and diminish the intertwined sex and race aspects of the harassment they experience, instead of viewing it as a totality. So the language that is in this bill provides a clear standard for when conduct rises to the level of unlawful harassment or when it doesn't, and that avoids those bad interpretations. And it's clear that harassment must intentionally treat someone differently. And to Senator Reeves' questions, that has to be based on a protected class like sex or race. And the harassment must be shown to unreasonably alter the terms, conditions, privileges of employment. In other words, it has to have an effect on the job. So that's a clear standard for Virginia that will avoid those problematic standards under federal law, and I'm happy to take questions.
All right, any questions? All right, thank you. Who's next?
Helen Hardiman, please go ahead.
All right.
Good afternoon, Mr. Chair, members of the committee. Helen Hardiman. I'm with the It's currently the Office of Civil Rights, formerly the Division of Human Rights at the Attorney General's office. And I actually receive and investigate allegations of violations of the Human Rights Act. I think this bill does a lot to remove some of the sort of fractured language where we're having to figure out what causes of action apply to what size employers for which protected classes. And so this definitely makes my job easier. I think all of the assertions that this aligns with federal law is true. I'll say it's probably the employee-friendly case law from federal statutes, but I think this would put Virginia ahead of the curve in making sure that folks are not discriminated against in the workplace. We support the bill.
Thank you. Any questions? All right, who's next?
Lee Strelka, please go ahead.
Good afternoon, Chair and committee members. Hi. Lee Strelka, I'm partner at a law firm in Roanoke. We focus on employment law and we support this bill. I've been asked to briefly bullet point a recent federal case in which a court found that racially harassing conduct was not severe or pervasive. This took away our opportunity to try the case in front of a jury. Our client was Dr. Andrews, who identifies as a Black female. She was the director of a university program assisting low-income individuals of color. She experienced constant negative commentary about her hairstyles and her ethnic attire. Her hair was regularly touched in an offensive manner, which is a battery. She was consistently called gal or girl in a derogatory way, which has historical racist undertones. Her supervisor made derogatory comments about historically Black colleges and universities, calling them filthy, unsafe, and bad schools, even though she was aware our client attended one of those schools. The employer refused to discipline a subordinate employee who made racist comments to Dr. Andrews and made false complaints about Dr. Andrews. And when she complained, she was retaliated against. So from our perspective, it's crucial that these outdated federal standards not be imported into Virginia's human rights law, and that we clearly define what constitutes harassment in Virginia. I'll take any questions. Thank you.
Thank you. Any questions? All right, who is next on?
Megan Healy, please go ahead.
Megan Healy.
Good afternoon, Chair and members of the committee. I'm Megan Healy, Governor Northam's Chief Workforce Advisor. I want to thank Senator McClellan for carrying this bill. It's very similar to a bill the administration supported last year. We believe, the governor believes, and all the administration, that no one in Virginia should be discriminated against and specifically harassed. Thank you.
All right, any questions?
Todd Gaffey, please go ahead.
Todd.
Thank you, Mr. Chairman. Todd Gackey with the Family Foundation, and we are actually opposed to this bill. While these definitions are based on various sources, we just want to point out some of the ambiguous language that raises our concerns. On lines 80 through 82, the language would suggest that any conduct on the basis of sexual orientation, gender identity, or et cetera, would be considered workplace harassment, regardless of whether it is direct or indirect or verbal or nonverbal. Therefore, almost anything could legitimately trigger a harassment charge against the manager or coworker or result in disciplinary action or termination. And also the nonverbal could suggest that an employer or coworker could potentially be accused of harassment, not just because of what they say, do or say, whether directly or indirectly, but for not even interacting with someone at all. And it's going to force employers and employees to choose between certain speech or a language, or whether or not to engage or not engage in certain activities that could violate their personal conscience or religious convictions, or face harassment charges, because not doing so would be considered creating an intimidating or hostile environment. I think that these vague and highly subjective terms therefore kind of raise the concern that there's a lack of due process. But finally, I want to point out that on line 216, workplace harassment can occur even outside the workplace. So this is very concerning, in which a person's conversations or actions or beliefs outside the confines of the workplace could also be used to charge someone with harassment. So our concern is that this bill would actually have a negative impact and do more harm to the work environment. So we urge you to vote against this bill. Thank you.
Mr. Chairman?
Mr. Chair.
Questions? Senator Evan.
And I think Senator Boysko was asking as well. I wanted to ask the last speaker, when he says harassment outside the workplace, wouldn't he, or maybe just point out to members of the committee if he's not available, but if someone were to call an employee at home from their home outside the workplace and harass them, and their relationship is through work, I would consider that harassment, whether or not it occurred in the workplace. And I think it's important that that remain.
All right, Senator Boysko.
Mr. Chairman, is the gentleman still on the line?
I am.
Great. I'd love to ask you, what would you think would be appropriate harassment? You seem to have some concerns about thinking that that it was out of the scope of what was normal. And so the way I'm reading it, it seems pretty reasonable to me that you wouldn't want to do things that would unreasonably alter an individual's terms, conditions, privileges of employment, including creating an intimidating, hostile, or offensive work environment. And so I'm wondering, when do you think that would be appropriate?
Well, no one is suggesting that the harassment is appropriate. What we're concerned about is some of the ambiguous language regarding direct or indirect, verbal or nonverbal, whether if you make a comment or a gesture at work and someone else picks up on that and relays that to someone that you work with, that could be misinterpreted. And so we want to make sure that the language is tight so that any types of misinterpretation are not misconstrued as harassment. Now, as far as the outside of the workplace, that is true. I don't think anybody would argue that calling a coworker at home and harassing them is appropriate. I think what we're saying is that so much of our private lives, conversations, it can be misinterpreted what you do outside of the workplace, and that shouldn't be held against someone and charge them with harassment in certain situations. So we're just saying that could be very, very problematic when someone is making an accusation of harassment.
Mr. Chairman, I just wanted to make a comment. The unreasonable alter standard will not let a slip of the tongue be used in this situation. Harassment must still be intentionally treating someone differently on a prohibitive basis, and it must impact their job. So I'd just like to make sure that we're clarifying that we're not talking about somebody who flips the bird off once in a while. Thank you.
Mr. Chair.
Senator McClellan, you want to
Yeah, if I may,
respond on that?
just from a legal perspective, I mean, again, I point you to, it is action that must unreasonably alter an individual's terms, conditions, or privileges of employment, including by creating an intimidating, hostile, or offensive work environment. Again, the outside of the workplace, that is codifying federal law, that is to get at harassment that could occur outside of the physical office building, like if you were at a work function or if you call someone. And I guess the example that the gentleman gave, if someone overhears something and then tells somebody else, you still have the normal rules of procedure that have to apply, the rules of evidence. Hearsay is not going to be enough to trigger a complaint. And again, the courts and the EEOC under federal law have already recognized instances where certain behavior can be actionable on the basis of sexual orientation and gender identity. You still have to follow the factors on whether it is harassment. So I think, as Senator Boysko said, just a one-time slip of the tongue or something like that is not going to be enough. This is just codifying what's already case law in both in federal law.
All right. Is anybody else to speak?
Two. Nicole Riley, please go ahead.
Hello, Mr. Chairman and members of the committee. Nicole Riley with NFIB. Unfortunately, I got feedback back from my attorneys earlier this morning on this particular legislation. Unfortunately, neither we nor any other business group that I could tell was part of that stakeholder group that met in the off season. So we haven't had a lot of time to digest and try to see the implications of this legislation. Initially, what they have said to me, some of the concerns, one of them was the significance of that early section that you guys have now amended out of the bill. So we appreciate that. That did take care of at least one of our significant issues. But our attorneys, and I guess this is where attorneys make money, right? They disagree on the definition of workplace harassment. They believe it's pretty vague and broad. And like I said, not being a part of the conversation to see what that is and how that would apply. I don't have any specific suggestions right now, but that certainly is an issue. And I think what always concerns us on behalf of our small business owners is even though the law may set certain standards, it does not prohibit, obviously, court action and a lawsuit being filed and starting the process. And for many small business owners, legal resources is not something that they have money to spend on most of the time. So the reason why, Mr. Gacke was making the comments that he was in some regards of making the language very tight is so that small business owners aren't seeing a lot of complaints and trying to defend themselves because they don't typically have the resources. And instead, they tend to settle much earlier in the process than their larger companies. So it's for those reasons that we oppose the bill still at this point. Thank you.
All right. Anybody else? One more.
Doris Kraus Mays, please go ahead.
Yeah, I'm Doris Kraus Mays with the Virginia AFL-CIO. So thank you, Mr. Chairman and members of the committee. And I really want to thank the senator for bringing forth this bill. We stand in support of this bill because we think it provides a clear definition of harassment that reflects the realities of the workplace harassment. So for those reasons, we support the bill. Thank you.
All right, thank you. That's it then. All right. Are there any other questions or comments from the committee members? Yes, Senator Ruff.
Thank you, Mr. Chairman. I don't think any of us want to see discrimination, but I have a great deal of concern of dropping this down to the level of 5 employees. Small businesses, we have often exempted small businesses from certain regulations. In this particular case, a small business is not going to have the money to pay the fines or to pay the penalties necessary. So they will make settlements rather than defending themselves when they believe that they have not done anything wrong.
All right. Any other?
Mr. Chairman?
Yes.
Mr. Chairman, back here. Question for the patron. One of my concerns is the timeline extension going from 180 days on line 22 all the way to 2 years, so 720. That's a huge difference. My understanding was the AG had recommended 180 days. So I'm wondering, why are we going that far? I mean, it makes more sense to me. Workplace should be longer than non-workplace, but at the point we're at now, I mean, 2 years seems like a big expansion there.
Again, under pregnancy discrimination under the Human Rights Act is currently 2 years. And tort claims for similar, if this rises to tortious acts, is 2 years. Breach of contract is 5 years. And other states have also gone to in some cases, 5 years for workplace harassment. Again, this is not going to court. This is how long you have to file a complaint with the Attorney General's office. When you go to the Attorney General's office, normally there's mediation. Normally, and this is not your question, but to Senator Ruff's point, if there's no definition in the code, then employers have to go to case law. And if you're not large enough to have an in-house lawyer, you're probably going to be looking for some kind of clarity. And you get that clarity sometimes when you go to the Attorney General's office. So that's why we've gone to 2 years, is to make it consistent that just because it's pregnancy discrimination rather than race discrimination, What is the logical basis to say it is 2 years for pregnancy discrimination, but it is not, it's 180 days for race? If it rises to the level of sexual assault, it's 2 years. If it doesn't rise to that level criminally, but psychologically it could still cause the same trauma, you get 180 days. And if you've been unlawfully discharged, in 180 days, you have to deal with what happened, look for a new job, and oh, by the way, I got to remember to file my complaint at the Attorney General's office. So that's why we moved to two years. I can give you a list of states that, and at the federal level, it's 300 days. So, but in Maryland, New York, Oregon, California, it's 2 years. Kentucky is 5 years, Ohio, it's 6.
Mr. Chairman,
Yes.
following up on this, I hear what you're saying, and I get those different categories. I mean, I like the legislation. I'm just a little concerned with this much of an across-the-board increase. I'd be much more comfortable if we went to, say, 360, so 1 year versus 4 times the amount for everything. That being said, I don't know if the patron would be willing to potentially pass it by for the day so we could possibly work on this a little bit.
If that's the will of the committee, but
Mr. Chairman, I have to be honest, it concerns me that employers, to get to a really good solution here, it would have been great to have a conversation with small business owners and employers as this was worked out to build that consensus. And I think a week gives them a chance to talk with their lawyers and come up with something that maybe is a better product that has that inherent consensus. And if the patron wouldn't mind, I would love to have a week to see if that consensus could be built.
if that's the will of the committee.
What's that?
If that's the will of the committee, then yes.
All right, does anyone want to make a motion?
Mr. Chairman, I have one question before we have a vote on that for the patron. So we heard the concerns from the business community that there were just going to be a bunch of new lawsuits. Could you clarify what exactly happens, what the process is, so that we understand? Is there an administrative process that is out of the courts versus everybody just going into a lawsuit?
And Helen Hardiman, who actually receives these, can jump in if I get this wrong. But what happens is you file a complaint with the Office of the Attorney General, you go through the administrative process, you have to exhaust all of your administrative remedies before you can even file a lawsuit in court. More often than not, particularly with small businesses, it's worked out at the administrative level. And Helen can probably provide more detail if you'd like more detail around that.
Mr. Chair, I'm here if she would.
Yeah. Senator Boyce, go.
Excuse me. In other states, do you have data on how many new cases were filed, and have there been an increase in lawsuits around the country on these?
I mean, again, the idea here is to reduce lawsuits by providing in code a clear definition of what is workplace and sexual harassment. Absent a definition in the code, you have to look to state and federal case law, which defines what we have defined here is already illegal under federal law. And so if you are a small business, if you do not have an employment lawyer on retainer, you're going to have to hire somebody to tell you what is workplace harassment, what is sexual harassment, rather than just looking at the code. Just like when we passed the Pregnant Worker Fairness Act last year, it was to provide a clear definition of what is pregnancy discrimination, which we saw in other states that passed that law. It actually reduced litigation. We have not seen an uptick in the litigation in Virginia since that law has passed. I don't know how much it's been reduced because it's only been 6 months, but we haven't seen an increase. And in other states that passed that, they saw a decrease. We expect the same here, because when you are providing a clear definition that combines the case law in one place, that is less of a burden on employers, and particularly small employers who don't have an HR department who can regularly give training and guidance on what is or is not harassment.
All right. Any further questions, Senator? Yes, Senator Lott.
Senator McClellan, when did you file this bill?
I probably filed it on the first day. It is similar to a bill that I believe Delegate Watts had last year. And my understanding is there was a bill last year that had a workplace harassment language that was very similar. So I filed this on the first day of session.
So on the first day of session?
Yeah.
Today. So.
Oh, okay. And had you heard from anyone?
I had not, but again, this is very similar to a bill that was filed last year.
So you did not have any conversation with anyone from small business community or any other comments that you've heard today with regard to your legislation until today?
The people that testified today, not until today.
Okay, thank you. So what can change in a week? It would be my concern.
Senator Ruff, you have a comment or question? Okay, all right. Senator Donovan?
I turned mine on, yes, sir.
Okay. All right. Is there any further discussion or questions? Anyone wish to make a motion? All right, the motion to pass it by for the week is that, pass it by for the day, which would be a week. Is there a second to that motion? Second. All right. All right, we have a motion and a second to pass it by for the day, which would mean we put it on the calendar for next week. Any further discussion? All in favor say aye. Aye. All opposed, no. All right, the motion, the chair's ear heard a little more on the aye side than the no side. So we will pick this up next week then. So and tell Senator Sproul to come on in. So. Senator Sproul.
Honorable sir, how you doing today?
I am doing fine and dandy. How about you?
One day at a time, one day at a time.
That's right.
Everything cool?
Senate Bill 1296.
Thank you, Mr. Chairman and members committee. This bill is put in as an administration bill, and what it does, it establishes and maintains an emergency management equity workforce group. It is to ensure that emergency management programs and plans provide support to at-risk individuals and populations disproportionately impacted by disease. The workforce group should include experts from the Governor's Office of Diversity, Equity, includes other state agencies, the public at large, and the private sectors who have expertise related to at-risk management. That's what it does, to establish and maintain an emergency management workforce group.
All right.
Now, I think we have someone from the Governor's Office on standby for any question.
Okay. Are there any questions of the patron on this bill?
Mr. Chairman?
Yes, Senator Mason.
So Senator Sproul, you're really looking at maybe older areas, neighborhoods, regions, that if impacted by an emergency or a disaster, you're trying to set up a plan for some of these places that you know could get hit hard, might have a hard time getting to them, getting them out, evacuating. Just really looking at old areas that, if hit by a disaster, would be disproportionately impacted.
Yes, sir. Mainly that and other areas too, but mainly the old areas, so they wouldn't have a department and on standby for it. Yes, sir.
Great. Thank you. Thank you, Mr. Chairman.
Are there further questions? All right, is there anyone signed up, anyone on the line to testify?
Dr. Janice Underwood, would you like to speak?
Yes.
Yes.
Good afternoon, Mr. Chairman and members of the committee. My name is Dr. Janice Underwood, Chief Diversity Officer for the Governor's Office of Diversity, Equity, and Inclusion. We strongly support this bill. We support this bill because the COVID-19 pandemic exposed many already existing inequities and even deepened them for underserved communities. Therefore, an equity working group as part of every future emergency declaration or state unified command is necessary, and this bill will create a permanent equity working group in the Department of Emergency Management that will focus exclusively on the needs of underrepresented populations for those who are disproportionately impacted by disasters. Happy to take any questions.
I believe there's a motion and a second.
All right. What's that? All right, motion and a second. All right, we got a motion to report and a second to that. All right, any further discussion? Okay, we'll vote on the board.
Senator Ruff, how does Senator Stewart vote?
Senator Stewart votes aye by proxy.
All right.
Senator Vogel votes aye.
All right. So 14.
Ayes 15, nays 0.
All right.
Thank you, Mr. Chairman. Thank you, committee.
Thank you. He's on his way. Okay. Lionel, if Open Shane's out there, tell him to come in. Okay. All right. Okay. No one's out there. Senator Pike. Yep. Senate Bill 1305.
Thank you, Mr. Chairman. Senate Bill 1305 is a Virginia Public Procurement Act bill. What it sets out to do is to resolve a couple things that you've probably noticed around both the state in terms of, you see protests at VCU. Many of you heard some of the issues at our own General Assembly building in terms of wage theft and worker misclassification. There's been numerous examples in higher ed and local government and other areas. In fact, there's been multiple suits that have been brought up over the last year. One of the issues, Mr. Chairman, members of the committee, that I was approached with was try to figure a framework that becomes more responsive on the contract side. And a couple of the elements that, as I talked to folks in procurement agents and project managers, found is that they felt they do not have an immediate tool within their tool belt, in other words, in their contract, to deal with the issues where there's found to be violations of labor law. What happens is there's inevitably, you have to wait on Department of Labor to then investigate the reports based on the findings of the labor law. What this does in a very simple one-page format is assigns what's basically a 90-10 rule. Many of you are probably familiar on a design, build, and CM at risk code. We have a provision already in the VPPA Act that says that the contractor and the design builder CM Risk can perform no more than 10% of its work by its own forces. This sort of flips it and says, we are presuming that you are if a subcontractor of the contractor, 90% of the work will be performed by its own forces, i.e. employees, and not independent contractors to that sub. The reason why 10%? Well, frankly, in typical contracts, we know that there are going to be independent contracts. And so for ease of implementation from the project managers and contractors that are on board, it's sort of an easier demarcation line of the sand. Furthermore, the bill lays out a provision, should the subcontractor exceed the 10% threshold, they simply send the documentation to the contractor for certification. They sign to the project manager saying they're conforming with the labor laws and terms and conditions of the contract. And so it would be covered as a basic template within terms and conditions of our contracts throughout Virginia. It has a $250,000 threshold and above, and so smaller contracts would not apply to this. And so it does take many tenets that are already in the Virginia Public Procurement Act, and frankly, it's my hope, because of the way it's laid out, it provides a much more easier to implement from a project manager standpoint and a procurement management standpoint than some of the solutions that have been presented to the body over years, and I know this committee has considered multiple ones. And so this was constructed really from the project management standpoint. Speaking with some of them over the last year and looking at some of the examples, they're frustrated, because they've worked on a project sometimes 3 and 5 years, and they're proud of the work they've done. And to develop it through budgeting, schematic, groundbreaking, design, and then towards the end of the project find out there's sort of issues in the contract that are blemishing an otherwise good project that's come on time and on budget. But the fact is that there are now claims of labor infractions that it's so far buried in the contract that they don't have direct repercussions, and they have to have an outside agency, DOLI, to resolve. Those investigations take 3, 6, sometimes a year or more to resolve, and by then, the public contract is already paid out, the contract is completed, and there's really no recourse for the ownership structure to correct that on a project, Mr. Chairman. So that is an overview of sort of why the bill is before the body and what it sets out to correct. I do have actually two line amendments, Mr. Chairman, to offer. All right. One of which is to first raise the procurement threshold to $500,000. Just from feedback from a few folks that say, well, there's, sometimes...
Line 16, 250 becomes 500,000.
Thank you, Mr. Chairman.
And the other?
And the other is to delete lines 35 through 37. Okay. Those essentially are provisions sort of setting out liquidated damages and other things. Those are already a part of number 5 above on lines 33 through 34. So it really is duplicated and is not needed within the code section.
I move the amendments.
All right. There's a motion and a second to adopt those two amendments. Any discussion, questions? All in favor, say aye.
Aye.
Aye. All opposed? All right, those amendments are adopted. Are there other questions or comments that any member of the committee wants to make?
Mr. Chairman.
Yes, Senator Ruff.
You said the current is...
Currently there's no provisions in our code in relation to the subcontract to contract relationship in terms of percentage. In our design build code and CM at risk code, there is a 10% threshold limiting that the contractor cannot do more than 10% of the work and basically have to sub out 90% of the work. In this case, it's sort of applying an inverse rule at the subcontract level. So I'm sort of picking up some sort of existing cues within our VPPA as it stands now.
All right. Are there any other questions or comments? Senator Donovan.
Mr. Chairman and Senator McPike, I'm just trying to understand why we need to micromanage this. What value does it add to procurement or contracts? Because we, with good intentions, often set a lot of these thresholds and benchmarks, and then we send these businesses scrambling to meet kind of artificial benchmarks, and I need to understand why this is important to how we procure.
Yes, Mr. Chairman. So what I'd say is, first off, most contracts theoretically should never have to use this provision at all based on normal, standard, good business practices, because you've got employees set up. In fact, the 10% rule sort of set up that recognizing you might have a specialty control contractor as a mechanical that you go to that is clearly an independent contractor. But what happens as an industry is the good businesses that you're talking about are undercut by subcontractors that are using essentially labor mill shops that are not employees but are lining up independent contractors, but under our federal law, they're basically avoiding paying employment tax, paying all the other tax, and cashing out to individual people, even though they clearly direct their work every day and should fall under employee classifications. So it's really trying to clean up and help the good businesses that are doing the right thing.
Well, Mr. Chairman, follow up.
Yes, Senator Donovan.
My good businesses in Richmond are very much opposed. And it's specifically, let me give you the name so that I get it right, my Richmond Area Municipal Contractors Association. And so I know that often the theoretical conclusion is that we're fixing a problem, but so often with these very specified percentile bills, we create so many unintended consequences. And I think there's a way for us to maybe incentivize the best practices that you're talking about with. I can foresee a situation that's an unusual situation. You just don't know, where something crazy happens and people have a contract and they have to find another way to meet the requirements of that contract, and all of a sudden they can't do that because they don't actually have their regular employees because somebody's out with COVID or whatever it is. And you know, I totally respect the sentiment. I just think code begets unintended consequences. And I can't support this based on the advice from my subject matter experts, but I wonder if there's a different way to do this that might cause less strain.
Mr. Chairman? Yes. So the initial request came in the form of, I don't know, maybe 18 to 15 pages worth of requests. And so working with procurement and project managers, I boiled this down to 1 page for exactly that point, because there were a whole lot of other things that people were trying to do. And I said, look, as a project manager for the last 25 years, I would be scratching my head about how to implement. And so taking cues from our existing Public Procurement Act and enabling our project managers to have a very simplified form built into the terms and conditions. Absent that, what happens is, again, the project management's hands are tied to an outside agency, versus right now, if they're actually enabled, they can send a cure notice to the contractor to say, we've been noticed by the state or by locality that you have an infraction, please identify it. And then they have an obligation through their contract to then resolve the requested issue if there is infractions, and then resolve it. Likewise, do the example of adding in an independent, additional independent contractors beyond the 10% threshold. It allows that under sections 4 and 5 in terms of what that, 3 and 4 in terms of what that submission would look like. And it's simply, as a part of your payroll application anyway, you're already listing out subs. And so if you have a change to that, you'd say, hey, we've got an issue we've got to resolve. Here you go. They're still conforming with all the conditions of the contract. And again, that's when you exceed that 10 and 90 rule. And so there is built-in a lot of flexibility already within this framework.
Mr. Chairman, follow up. I just got a text from a helpful advocate, and I just want to make sure I point this out as the kind of thing that I have a sense but not an expertise like the patron does. But you know, the assertion is subcontractors allow small business an opportunity to work on larger projects. For instance, the state wants 42% of state spend with SWAM business. This limits that work to 10% in these contracts.
So, Mr. Chairman, first off, try not to be too pointed, but to identify a SWAM contract that said that they're only getting 10% of contract is a little bit insulting to SWAM contractors who do very good work at very sizable scales. And so there are small businesses that can pull in and do form work, do concrete work, et cetera. And so I think people are really being de minimis to the size and scale of work what SWAM contractors can do. Furthermore, if they're meeting a SWAM contract performance requirement, they already have to document that in their contract terms and conditions. And so the SWAM contract far exceed what this says. So the SWAM contract requirements, if they're already having to lay out, they're already having to submit to the state or the governing body exactly how they're meeting their goals. This is way less than that requirement, Mr. Chairman.
Mr. Chairman?
All right. Yeah, Senator Boyko.
Thank you, Mr. Chairman. Question for the patron. I'm hearing from a local government who is concerned about this raising their costs, and I was hoping that you might be able to address that.
Sure, thank you, Mr. Chairman. I'm not sure how this would impact at all anyone's costs. Frankly, I don't think any local or state agency is interested in having a performance requirement that they cannot remedy in the contract, and that's what occurs now. And essentially, wage theft is theft of taxes. It's theft of employment and other taxes that should be paid to the state and localities and other impacts. And so, I would suggest it is avoiding other costs that are being deferred where you do have bad actors at the table.
All right, any other questions?
Mr. Chairman, I have a couple of concerns. One of them is that we are trying to micromanage these businesses. But let me give you one example. I have an excellent construction company that has been in business close to 50 years. They built several prisons for the state of Virginia. No problems at all. Because the big international companies have come in and taken a lot of the contract business, they now are doing more subcontracts for those larger companies. They may do a big percentage of that market, of that construction. This would eliminate them completely from the marketplace.
Mr. Chairman, how can the senator explain how he would envision that occurring? Because just as a point of example, I guess to clarify, a sub of a sub is clearly, for instance, if you're passing through a clear scope of work that is defined and not in violation of any labor law, there's clear pathways to identify if it exceeds in 1090 and it is not, for instance, cheating out of wages. So that is very clear, the ability to either, if they're already subbing in their direct contract, there's no issue whatsoever.
I may be missing, Mr. Chairman, I may be missing some of his response through the mask. I'm not sure, but I think that it probably would scare the big international companies from subcontracting with him to do a lot of the work. That they would just, okay, they go ahead and hire somebody else and put it on their payroll. Am I missing something there? And if you don't mind pulling the mask down.
Yeah, maybe to help clear it up. And so this completely identifies that the contractor themselves, they're going to subcontract out most of the work. Most GCs do, okay? And so it is in relation to the subcontract's scope itself to ensure that they are not subcontracting essentially out to labor mills in multiple forms. Now, if you have 3 or 4 other subcontractors, it's fairly clear to identify in your payment of values and your schedule of values in your payment application to the project manager. That's usually required as you actually submit before you actually get a notice to proceed on the contract, and usually lay out those values. And so I really don't see any conflict or any opportunity of any contractor in Virginia that is doing a business above board. I mean, clearly all of these would have no problem and probably will never have to interface with this procurement code. Those who are, in fact, cheating out of wages, that's what it's meant for, because they won't be able to meet these requirements without submitting something back to the project management under the terms and conditions of the contract.
Mr. Chairman, I fully understand what he's trying to accomplish. I was just not sure that it's not going to harm other businesses in the process. That's my concern.
Senator Bell.
Mr. Chairman, I apologize to patrons. I know we talked about this. I just received a message from Loudoun County, and I'm just going to read this. They are opposing the bill as long as it is a mandate. I don't know if there's the ability to make it an option, They believe that from their Department of General Services that it's going to increase costs in the contract process, preclude contractors the ability to find the most cost-effective solution that meets the contractual requirements. They believe it has a direct impact on their current budget and future budgeting for projects.
Yeah, Mr. Chairman, I'd say that's the similar question from Senator Boysko from earlier, also from Loudoun County. I did receive a copy of that, again, just a few minutes ago in terms of the notes. And there's no clear example of how those costs would be transferred or where the costs would be inferred. I mean, it's simply not evident whatsoever. Having set up, drawn, issued ITBs, scopes and specs for the last 25 years, and done bid buyouts and other things as part of the projects, this is not an impediment to any cost whatsoever. However, it does provide a tool for the project management as well as the procurement teams, as it would be required as the basic terms and conditions of the contracts. So I do think if they're reading it wrong, that might be the case, but that is not what each one of these sections of the bill does.
Mr. Chairman, thank you. Were you able to talk with Jeff Gore, Loudoun County's rep, beforehand, or?
Yes, I did. I offered, in fact, to reach out to talk directly to the procurement agents and officials and walk them through any of their questions and concerns about how exactly. I walked them through the intent and how that is structured. I did get feedback of maybe lifting the price threshold of the bill, which we just did. We struck it and doubled the threshold to 500 as part of this discussion, and additionally removed the section 6 and struck that section of the bill as well, Mr. Chairman.
All right. Are there any other questions? All right. Is there anyone signed up to speak from the public? Okay.
William Hefty, please go ahead.
Mr. Chair, members of the committee, this is Bill Hefty. I represent the Virginia Association of Governmental Purchasing, and we agree with Loudoun that our issue is that this is required of all public bodies in Virginia. It would be fine to have this in a toolbox if a locality wanted to use it, but we don't think particularly for small jurisdictions that this should be required. The bill as written says that if somebody wants to use more than 10% of less than 10% of their own employees, they have to notify the locality and give them justification for that, and the locality has to review that. In some cases, and we're talking about wage theft and other things, in some cases that may be an easy review. In other cases, that may be fairly complicated. And for a small procurement department to have to review every time a contractor on a construction contract wants to use less than 10% of his employees is a burden that has a potential cost, but also a potential time. And so our ask of the committee and the patron would be to make this optional for localities. Thank you.
Greg Ackerman, please.
Mr. Chairman, members of the committee, my name is Greg Ackerman. I'm the Northern Virginia Director for the Baltimore, D.C. Metro Building Trade. We represent 17 different construction unions and 24,000 working families in the metro area. We strongly support this bill and appreciate Senator McPike putting in this legislation. We were really disheartened to see just the amount of lawsuits that were filed against contractors performing works on public works projects, including the new General Assembly building. At this point, given the fact that the wage theft law has been in effect for about 6 months, the fact that hundreds of workers have already signed on to these lawsuits is a good testament to just how prevalent this issue is on public works construction sites. And we believe that Senator McPike's solution is a very elegant one, and we appreciate the work that he's put in to craft this solution. We are, again, incredibly concerned that without solutions like this, that the constant subcontracting out of liability to lower and lower tier subcontractors will lead to rampant wage theft on public works projects, as it clearly already has done. And we appreciate the fact that the solution is geared towards helping responsible, law-abiding contractors that currently have been unable to competitively, bid on projects in the Commonwealth. So we appreciate it.
John Harmon, please go ahead.
Good afternoon, Mr. Chair and members of the committee. My name is John Harmon. I'm here today to represent the Virginia Transportation Construction Alliance. VTCA represents over 300 firms in Virginia that design, build, and maintain our roads and bridges. We're opposed to this bill, which restricts our ability to use subcontractors to outsource more than 10% of their work for several reasons. First, transportation truck projects require many specialty subcontractors, and that pool is not very big to begin with. This bill will further limit this pool and the sub's ability to provide a complete scope while maintaining their budget. Second, most VDOT projects, as we're most aware, have a big impact to the public, and most of the projects have very aggressive schedules, and we're under enormous pressure to finish as quickly as we can. When a project has an aggressive schedule, one of the best ways to improve the schedule is to increase resources by both our own forces and our subcontractors. This limits our ability to go to our subs and get them to add resources to the work. Third, one of the penalties is liquidated damages for project delays. Every public transportation project already has these penalties for failure to complete on time. And I feel this bill actually has the opposite effect by increasing the risk of delays because we can't apply the resources that we may need to meet the schedule. Fourth, this bill hampers our ability to meet the DBE and SWAM goals, as already been discussed. Our subs play a big part in our role to meet the overall goals, and taking away their ability to go outsource and achieve these goals hurts our ability to meet these goals. And finally, the penalty for debarment for a year, in our opinion, is very severe and doesn't match the offense of simply trying to get the work done and to create as many opportunities as possible. This is especially worrisome for us in the current pandemic and in light of the tight labor market. So in closing, just quite frankly, we're not sure what problem this bill is trying to solve. The vast majority of construction projects, transportation related, are being delivered on time and on budget, and we feel this bill will hamper that ability. Thank you for your time.
Mr. Chairman, just to clarify, the committee already took action on lines 35 through 37, which the speaker was having objection to, which is in relation to the one-year debarment as well as liquidated damages. So just note for the speaker that the committee has already stricken that from the bill. Thank you, Mr. Chairman.
Robert Bohannon, please go ahead.
Thank you, Mr. Chairman. Rob Bohannon here on behalf of VTCA, just as Mr. Harmon was, as well as the Richmond Area Municipal Contractors Association. Wanted to echo the comments of Mr. Harmon, but also state that, what makes particularly these complex projects, what makes them successful is good contractors, not necessarily less contractors. And we've heard a lot about protections against wage theft and folks who are less than above board. The companies we represent are obviously law-abiding contractors. This General Assembly passed sweeping legislation protecting workers from wage theft last year. On the road construction side, you often have Davis-Bacon requirements, VDOT payroll audits. All those things are in place to protect against that already. So this is not, we don't see this as a tool to do that. We see this as something that would actually slow down construction projects that are already on tight timelines. Thank you.
Thank you. Next.
Jason Parker, please.
Mr. Chairman, committee members, thank you. Jason Parker, Virginia State Building Construction Trades Council. We represent the entire state of Virginia and all the construction disciplines. We support any legislation that will tamp down any form of labor brokers or misclassification. There's a lot of lost wages there. There's a lot of desperate stories there. There's a lot of lost taxes there. We think that the taxes would probably pay for any incurred expenses that no one's been able to explain. And we believe that this is good legislation and it's a moral imperative to stop these practices in the state of Virginia. Thank you very much.
Next. Michelle Gowdy, please go ahead.
Hi, Michelle Gowdy. I'm speaking on behalf of VML and VACO both, and we oppose this bill. Unfortunately, this is a unduly burden on our smaller localities, as you heard from Bill Hefty earlier this afternoon. We are in support of it as a tool in the toolbox, but not as a mandate. Thank you very much.
Thank you.
Matt Benka, please go ahead.
Mr. Chairman, members of the committee, Matt Benka with the Virginia Contractor Procurement Alliance. Our group represents many of your mid-sized general contractors throughout the state that construct your government buildings. I don't think this bill gets to the heart of the problem of what's being discussed, and there absolutely is a real cost to what's being discussed. An analogous bill, on at least on the healthcare side, might be requiring a surgeon to perform 90% of an operation on a hospital, on a surgery on behalf of a hospital. This bill just doesn't really fit into the real world of construction. I'd also note that there are two budget amendments on each side when it comes to wage theft, which will allow for 2 additional inspectors with the Department of Labor, and think that is a much better way to get at the heart of the problem that Senator McPike is trying to address.
All right, next.
Brandon Robinson, please go ahead. Please unmute yourself.
Good afternoon. Sorry about that. Mr. Chairman, members of the committee, Brandon Robinson with the Associated General Contractors of Virginia. Our members are commercial construction throughout the Commonwealth. We also oppose this bill for really a lot of the reasons that have been mentioned before, but the potential to increase the costs by mandating how the business gets done. Then it harms the flexibility that contractors use in order to use subs and sub out work to basically get the best person or the best company doing the best work for the best price out there. And it just drastically changes the nature of the business. So I think a couple of things were said, but good contractors does not mean less contractors. I believe someone said before me, and we would agree. So we'd respectfully ask you oppose this legislation. Thank you.
Jason Asher, please go ahead.
Good afternoon, Chairman, members of the committee. Jason Asher, Political Director with the Mid-Atlantic Pipe Trades, represent the United Association locals across the state of Virginia. We're in support of this bill. We appreciate Senator McPike for putting it in. We're in favor of anything that will get rid of the wage theft and misclassification problems we're having across the state in construction. Thanks a lot.
All right, next. One more, okay.
Victoria Leonard, please go ahead.
Hi, thank you. I'm Victoria Leonard. I'm the political director for the Baltimore-Washington Laborers Council, which is the affiliate of LIUNA that represents Northern Virginia. We have 7,500 members that are construction laborers, many of whom live and work in the state of Virginia. And as my colleagues have very eloquently stated the benefits of this bill, LIUNA supports this bill. We have seen in the last few years many examples of wage theft, worker misclassification on Virginia state projects. And so we appreciate Senator McPike's creative approach to addressing the problem, and hope you all will support this bill. Thank you.
Any other questions or comments?
Mr. Chair?
Yes.
Thank you, Mr. Chair. Last year, I carried the misclassification bill that would make sure that no one could retaliate against an employee who reported a misclassification. From what I've seen in the in some of the testimony here was that we have had a pretty big increase, pretty big showing of people who are claiming that they've been victims of wage theft. It seems to me that Senator McPike is trying to find a way to help us get in the right posture so that we don't have folks in that position anymore. And I'm wondering, with the business community, what if we did a pilot program for a year to see if it caused an undue burden? I think Senator Donovan suggested that we could look at it temporarily as a suggested amendment?
So, Senator Barker, you heard one of the speakers, Mr. Banka, imply that the state budget amendment for the additional 2 Dolly folks, sort of reinforcing it as sort of a great idea. Here's the problem. You still have the lead lag issue of both reporting, investigation, and then fining through Dolly. And again, one of the problems is you do not have the contract terms and conditions on the subcontract level, which is where this activity is occurring, in order to correct it. That time on a contract, those contracts are done. A lot of times the contract is wrapped up, you've already paid out and closed out and wrapped up by the time you have any sort of finding. And so, especially when it comes to public dollars, we have a higher threshold. We have a higher requirement. Dolly does private industry, they do everybody. But as taxpayer dollars and state taxpayers and local taxpayers, we have an onus and a higher standard to follow. And the fact is that as in our public contracts, we don't have the authority in issues to correctly rectify the issues going on. And so that's really what's at hand. And so the question before the body is, are we going to allow this to persist? You know, and unfortunately, some of the speakers had talked about costs. I have yet to have any identified cost or any limitations in any of the contracts I've run, nor limitations on the number of subs that I can have on my project, nor would it be in conflict with this, even with a simple procedure in place. And so this really is a fairly fine-tuned way for adding terms and conditions to be able to implement actions immediately on contracts and not cause, frankly, public embarrassment and harm where we're paying our own taxpayer dollars and not doing the right thing. I mean, that should bother us all at its core. At its very core, you're spending your dollars and cheating out wage from workers and their families. And that's really a part of the core, is the lack of ability for a contract manager to say, hey, we've received notice that there is issue. Here's a cure notice. Come back and provide us that this is not occurring, or rectify it through your subcontract. And that's, I think, critical and fundamental to this bill.
All right, are there any other questions or comments? All right, the floor is open for a motion.
Move to report.
Second. All right, we have a motion and a second to report. Any further discussion? All right, let's vote on the board.
Mr. Chair, I move that Senate Finance has asked for this.
What's that?
Senate Finance has asked for this.
Okay.
Report and refer.
The motion will be to report
And refer.
Finance. All right, let's vote on the board.
Senator Vogel, how do you vote?
Senator Vogel votes no.
Senator Stewart votes no.
Ayes 8, nays 7.
All right. Motion passes on a vote of 8-7. All right, could you get Senator Obenchain, who's been wandering around out there? So. Yes, sorry.
Mr. Chairman, members of the committee, I've got Senate Bill 1369.
Right.
Let me give you a little bit of quick background. There are different kinds of corporations in Virginia, just regular corporations that are owned by stockholders. There are non-stock corporations, and then there also are cooperatives, which are a form of corporations. There are general cooperatives like the electric co-ops. There are agricultural co-ops like many of the farm co-ops around the state. And now there are worker cooperatives. Many of the co-ops are member-owned, not stockholder-owned. So in my district and in Senator Evans' district and Senator Hashmi's district and many other districts around the state, there are agricultural co-ops that are member-owned that have participated in the SWAM program. They've been certified, participated for many years. This year, the Department of Business Diversity started doing a review of the eligibility of participants in the SWAM program, and they determined that the definition of a business requires that they be businesses that are owned more than 50% by individuals. That's what the statute says. The reg that's adopted under it speaks of shareholders owning the corporation. And they decided that member-owned cooperatives who are owned perhaps by farmers are not stockholders. And as such, they are not businesses and are not eligible to participate in the small business component of the SWAM program. We don't think that that was the intent of the legislation. We think that the regulations simply didn't take into account the fact that there are member-owned businesses across Virginia, and we in fact found that there are 29 agriculture cooperatives in Virginia that are member-owned. There are approximately 80 general cooperatives that are member-owned in Virginia. I don't know whether anybody has organized as a workers' cooperative yet, but if they do, under this interpretation, none of them will be eligible to participate in the SWAM program because they are not stockholder-owned cooperatives. So what this bill does is it makes it clear that the definition of businesses includes not just stockholder-owned corporations, but the ultimate small business, businesses that are owned by members, which are like farmers. And if you don't understand, if you've not dealt with a agricultural cooperative, I'd be more than happy to describe to you in more detail how it works. But the Department of Business Diversity said, we feel constrained when it was raised, we feel constrained by the language of the regs and don't have the discretion to say that they ought to continue to be allowed to participate in the program and indicated that they are going to continue to review the eligibility of co-ops across Virginia. And in fact, since the Page Farmers Cooperative was decertified, my understanding is that there have been other co-ops across Virginia that have been decertified as well. So, I've talked to Secretary Ball, shared with him a copy of the statute. He's not gotten back to me. I've tried to work cooperatively with the administration, and I don't know where it is. I've not heard that they are opposed to it, and I can't imagine why they would be, but I would tender the bill.
Mr. Chairman, Senator Obenchain, I listened to your explanation. Could you give us an example? You mentioned DePage County. Could you give us an example of what they are doing that they'd be precluded?
Selling milk to the schools.
Thank you, Mr. Chairman.
Do we have anyone signed up to testify on this one?
Katie Reams, please go ahead.
This is Katie Reams and Mark Ramsey. I'm the Director of Nutrition Sales and Marketing for Culpeper Farmers Cooperative, and Mark is our General Manager. We would like your support of this bill. We are a farmer cooperative. We are owned by our farmer members who are our patrons. Our board of directors is involved with the management, which is kind of part of all the qualifications that are outlined under SWAM to be certified. We've been SWAM certified for the past 13 years until this year, and we're kicked out because of the sole fact of not issuing stock. However, I would argue that because we do have patrons as members and we do pay patronage, that is the same thing as stock. There are no businesses currently listed on the SBSD directory website to be able to supply feed or minerals under agriculture. So all of your university farms, your ARECs, Department of Corrections farms, there are no businesses listed there under SWAM to be able to supply them with goods and services, which provides a great challenge not only for them, and of course, you know, as a local business, we would definitely like to be able to work with them and service them. However, with this change in interpretation, that's not being allowed currently. And I will also say that I feel like our cooperative is kind of the epitome of what SWAM is about. Our president of the board of directors is female. She's actually the first female president that we've had. I am a female director. Our controllers are female. We have several managers that are females as well. And we have several minorities in various leadership positions throughout our company as well as on our board of directors.
All right, well, thank you very much. Anybody else to testify?
Dan Holmes, please go ahead.
Thank you, members of the committee. Mr. Chairman, I was not aware of this bill until I just heard it introduced. And I'm not speaking on behalf of any organization. I'm just speaking as a citizen of the Commonwealth. Fully support the bill. Having worked at a co-op, they are true, as Senator Obenshain mentioned, they are the epitome of a small business. And if this supports our agriculture and rural economy, I'm in full favor of it. Thank you.
Thank you. Okay, that's it in terms of the public testimony we have.
And I would point out, it doesn't in any way change any of the qualifications that exist in the statute for participation in the program.
All right, are there any further questions of Senator Locke?
So the only thing, I'm sorry, Mr. Chairman, the only thing that prohibits them from participating is the fact that they don't own stock.
That's correct. And these businesses, they don't issue stock. The way they're organized is their owners are their members. They were organized under this part of the corporate code by a group of farmers. And the code specifies the purpose for these cooperatives, that farmers can come together and through this cooperative leverage the quantities that they sell in order to support the farm economy in that region. And so they get patronage checks, small checks from the cooperative for their patronage, their participation as owners, as producers. They also sell to the cooperative and are paid, but the members are the producers and they are the owners, and they are essentially stockholders in every other way.
Chairman?
All right.
When it's appropriate, of a motion, move to report 1369.
All right, we have a motion to report the bill. Any further discussion? All right, let's vote on the board.
Senator Vogel, how do you vote?
Senator Vogel votes aye.
Stewart votes aye by proxy.
Mr. Chairman.
Ayes 15, nays 0.
Thank you very much.
Yes, Mr. Chairman.
If you would like, we can start with SB 1314. Thank you, Mr. Chairman and members of the committee. SB 1314 establishes a office to assist us in really targeting the needs of workforce development and addressing the alignment of the students that are coming through various and different programs, aligning those curricular programs with the targeted areas of workforce development. So what we seek to do is to establish an Office of Education and Labor Market Alignment to coordinate data and analysis on workforce and higher education needs, and then also to effectively translate that to various partners across the state. This is a partnership with SHEV and with institutions of higher education, with our Virginia Employment Commission, Go Virginia, and other relevant agencies. At present, we have data coming from a variety of different sources. We have needs assessments that are emerging, but we don't have a coordinated effort in actually being able to project what our Commonwealth is going to need 10 years from now, 20 years from now. With this office in place, we would have the ability to forecast what curricular programs need to be prioritized, what skills and knowledge our students will need, even in middle school, high school, and then be able to effectively work to address those concerns. We've had past incidences in which the Commonwealth was caught off guard, particularly in the area of technology and technology skills development. We have Virginia students ending up leaving the Commonwealth and going to other states because the jobs have already migrated to those states as a result of our the Commonwealth's not being prepared with the effective workforce. And so this would help to address those concerns and make sure that we have the ability to move forward strategically and effectively as a state.
All right. Are there any questions of the patron? All right. Are there members of the public to speak on this one?
Eric Ryson, please go ahead.
Thank you, Mr. Chairman, members of the committee, and Senator Hashmi. My name is Eric Ryson, and I'm the Director of Public Policy for the Virginia Chamber of Commerce. On behalf of our more than 27,000 members, our partners at several local and regional chambers of commerce, and other members of the business community, we support this bill. As part of our Blueprint Virginia 2025, a business plan for the Commonwealth, we specifically call for better alignment between education, talent development, and employment opportunities. And the fact of the matter is that many in-demand, high-paying jobs are going unfilled in the Commonwealth. So we support any measure that goes to better match talent with opportunities, and we think it's critical to the success of our economy, employers, educators, and workers. So thank you to VEDP, SHEV, Senator Hashmi, and all the other partners for carrying this important initiative, and we think it'll lead to real-time data that Virginia can use to get the right policy decisions. So thank you.
All right, thank you.
Clayton Medford, please go ahead.
Mr. Chair, Senator Hashmi, members of the committee, thank you for allowing me to speak today. I'm Clayton Medford, speaking on behalf of the Northern Virginia Chamber's 700 members and 500,000 employees in support of the bill. Also speaking on behalf today of the Northern Virginia Back to Work Coalition, which is a group of chambers, universities, and workforce agencies that are united in support of education and workforce development funding during this economic recovery. This General Assembly has shown a dedication to improving educational access and outcomes in the Commonwealth. And this new office is among the many steps that you have taken along with the administration to connect the numerous workforce development efforts and to grow workforce development ecosystem in the Commonwealth. And we ask that you keep Virginia on this innovative path and report the bill favorably. Thank you.
Peter Blake, please go ahead.
Good afternoon, Mr. Chair, members of the committee. Senator Hashmi, thank you for the opportunity to speak to you. I'm Peter Blake, Director of the State Council of Higher Education for Virginia. This initiative grew out of a year-long study that Chev conducted under the leadership originally of Haywood Fralin, our chair. And we're pleased to promote it, support it, do whatever we can to see that this gets established and that we do have a central, authoritative, and credible source of data, information, and advocacy so that we can do a better job to align labor market needs with the academic programs at our colleges and universities and other education and training providers. So I'm pleased to support this. Thank you.
Christy Morton, please go ahead.
Hi, thank you. Mr. Chairman, members of the committee, my name is Christy Morton, and I'm the Vice President of External Affairs at the Virginia Economic Development Partnership. I would like to thank Senator Hashmi for patroning this bill. As the Senator has stated, and my colleagues here, the office this bill would create will have a significant impact on our ability to provide Virginia's educators and policymakers real-time data on the linkages between education and employment outcomes. This initiative will help Virginia to lead the way on talent and help you all make critical decisions to effectively respond to the talent needs of Virginia's economy. This bill is supported by multiple organizations, including the Virginia Economic Developers Association, the Virginia Business Council, the Virginia Chamber of Commerce, who you've heard from, and the Port of Virginia, among others. So thank you for your time, and I'd be happy to answer any questions that you might have.
Fran Bradford, please go ahead.
Great, thank you. Good afternoon, Mr. Chairman and members of the committee. I am Fran Bradford, the Deputy Secretary of Education, and I appreciate a few minutes just to say how supportive the administration is of this important bill. We are grateful to Senator Hashmi for carrying the bill and to Chev and VDP and others for bringing this forward. This bill offers Virginia an opportunity to move purposefully and consistently engaging other stakeholders in identifying the workforce needs of the Commonwealth and aligning those with our educational efforts, not just in the traditional traded sectors, but also in critical areas like healthcare and education. This bill is a true nexus of Virginia's efforts to be the best educated state in the nation, as well as the best state for business. And I hope that you will support the bill. Thank you very much.
That's it. All right, that's all the public testimony. Are there questions or comments?
Mr. Chairman, I have a question.
Senator Donovan.
Thank you, Mr. Chairman, and Senator Hashmi. I'm just curious, have you connected in the Data Analytics Commission and Carlos Riviera with this project?
Sorry, could you,
No,
Senator,
certainly.
could you repeat that?
The connecting in the Data Analytics Commission, Data Commission, and the they're building data trusts. One of the challenges to finding a cross-section of this information is that has historically been that the information is in different silos around the state. And that makes it very, very hard. We've had to give permission in the past to say Chev or even to Workforce. There's budget language in this year to help Workforce with their attempt to align income and other pieces of the data that help you understand how you go from education to workforce and jobs. And even if you're getting paid a commensurate rate for, say, for instance, a college education. And we know we're not. We know that a lot of our college graduates are underpaid from what we expect them to be. So I don't know if there's a way to include this in your bill or perhaps offer a friendly amendment that it would be an amazing asset for you to align with the Data Commission and Carlos Riviera, because he's building those data trusts where he can help align these different agencies to accomplish your goals.
Thank you, Mr. Chairman, and thank you, Senator Donovan. I agree that there are a lot of different sources that are creating data, not just what you have mentioned, but also in Georgetown, we've got the outstanding work of Tony Carnevale, who should, that research should also be integrated. The positive element about this particular office is that it really will work to fill those gaps of alignment, and it will certainly be leveraging any existing data that is present. I would hesitate to specifically define the data sources that we were going to use, because this office will be reaching out and identifying those sources, and there are multiple sources right here in the Commonwealth as well as outside of the Commonwealth that they will be using.
Mr. Chairman, just to follow up. The Data Commission isn't actually a source of data. It's a place that builds the data trust where it takes all those data points that you want and it puts it into a data trust where the information can be exchanged, but also privacy protected, so that multiple agencies can utilize that data to ask questions and find answers across the silos of data storage in Virginia. So it's more of a how to accomplish the goal than it is a what will be accomplished. And so I actually have a budget amendment that talks a little bit about data analytics, looking at overcoming some of the hurdles to aligning this data. But this is a real problem in the goal you seek to achieve. And you can put it in the bill or not necessarily, but that's a great asset that the state has that is available for your help, and you may want to include it in the bill because that gives them the power to help.
All right, any other comments or questions? Senator Evans.
Yeah, just to comment briefly, Senator Donovan's right that that initiative will be helpful, but I think this has to be established before it's partnered with. And I hope the folks in the administration on the phone who are listening will make use of it.
All right. If there are no other comments or questions, the floor is open for a motion. Report. Second. All right, there's a motion and a second to report. And this one will also need to go to finance. All right. We are set with a motion to report and re-refer to finance. No further discussion. We'll vote on the board.
Senator Vogel, how do you vote?
Senator Vogel votes aye.
Stewart votes aye.
Ayes 15, no 0.
All right. That one passes 15-0. Senator Hashmi, Senate Bill 1318.
Yes, absolutely.
All right, here's my question.
Thank you, Mr. Chairman. SB 1318, and I know we've had quite a few folks who are wanting to speak to this bill that are been waiting patiently, but I do have a question for staff. We had a substitute that was introduced a little late in the day, and is the substitute now available?
Mr. Chairman, Senator Hashmi, I have line amendments. Is that what you're referring to?
Yes.
Yes, I can send those over to LIS now.
Thank you.
So give it a few seconds and it should pop up on LIS. And I can also read those if you'd like, Mr. Chairman.
Yeah, could you either read them or if they're lengthy, summarize? So.
Well, it adds a member. I'll let Senator Hashmi summarize them, but the changes are on line 27 after the word impact, the impact. Insert comma, both positive and negative. On line 90, after least, strike 13 and insert 15. Also on line 90, after consist of, strike 12 and insert 14. And lastly, on line 94, after council, insert comma, one representative of an environmental justice community or environmental justice advocacy group to be appointed by the governor, one representative from the regulated community to be appointed by the governor, comma, and then the rest of the sentence is as is in the bill.
I move to accept the substitute or the line amendments.
All right, we have a motion to adopt the line amendments. All right, there's a second to that. No discussion. All in favor say aye. Aye. All opposed, no. The line amendments are adopted.
Thank you, Mr. Chairman. SB 1318 is building on the Environmental Justice Act that we passed last year in the 2020 General Assembly. If members may recall, in the Environmental Justice Act, we established definitions of what we mean by environmental justice in the Commonwealth, and particularly defined those communities who are most often negatively impacted by decisions of environmental impact. Last year, we embedded a great deal of language about how to go about establishing the work group, the interagency work group that would be involved in assessing issues of environmental justice. That language was placed in the budget and has been successfully implemented. This year, through SB 1318, we are seeking to move that language out of budget and now put it into legislative action here, and that's what we have done in essence, defining what the interagency work group is going to be doing, how it will be structured, and the kind of responsibilities it has and its composition as well. And that is, in essence, the context of this bill.
Are there any questions of the patron on the bill?
Yes, Mr. Chairman, I have quite a few. So I'd like to start, Mr. Chair, Senator Hashmi, with on line 27, that you just amended to add cumulative impact. And I guess that's referenced somewhere else in the bill that maybe you can point me to. But as I read this paragraph, what would not be included in cumulative impact?
What would not be, I'm sorry,
This
Mr.
just
Chairman.
and you even added the impact of the impact positively or negatively. So this just strikes me as every single thing possible. And so I'm just wondering if you can connect me to where we reference it later, because that definition is wide open.
Mr. Chairman and Senator Mason, it is a broad definition, you're correct. It is in the context of environmental issues, and so when we're thinking about environmental issues, it is impacts to our air, soil, and water, and those are the concerns that are under consideration here. And so when we're thinking about cumulative impact, it would be the accumulation of toxins, as an example, within our air, soil, water. It would be such things as the impact of carbon, the impact of other pollutants that may be affecting our health and our environment. So it is really the impact that occurs over the course of time, not necessarily just in one particular instance.
Mr. Chairman.
Yes, Senator Mason.
And I may have misread it. So incremental impact of a covered agency action. So would this be only actions taken previously by agencies of the Commonwealth?
Mr. Chairman and Senator, that's correct.
Okay. Mr. Chairman.
Senator Mason.
So then down on 65, by October of this year, each agency has to have a full-blown report outlining any impact they have had across. I guess I'm asking, I see all the Romanettes that it speaks to the policy, but can you walk me through what each agency would be reporting on by October?
Mr. Chairman and Senator, this is a requirement that the agencies of the Commonwealth are going to be adopting their policy first and addressing what the environmental justice consequences of their actions would be. The policy is addressed here. The policy shall require the agency to consider environmental justice and any cumulative impact in the administration of the agency's laws or regulations, consistently identify environmental justice. So the first actions are really just to establish the agency's specific environmental actions, and also to designate a person within the agency who would be the individual responsible for having that connection and outlining what the connection to the work group and outlining what its specific actions are.
All right, are there further questions? All right, is there anybody to speak on this?
Connor Kish, please go ahead.
Mr. Chairman, members of the committee, thanks so much for your time. Connor Kish with the Sierra Club Virginia chapter. We strongly support this legislation. Thank Senator Hashmi for carrying it. We believe the continued focus on environmental justice within each agency is critical to the goal of making sure that underrepresented and often overlooked communities have a voice at the table. So we really urge you to support this bill. Thank you for your time and for your work.
All right. Tynesha Griffin, please go ahead.
Good evening. This is Tanisha Griffin, the Environmental Policy Research Analyst in the Virginia Majority. We also strongly support SB 1318. We believe strengthening the Virginia Environmental Justice Act is essential to ensure that Black, Latinx, and working class Virginians are informed, thoroughly considered, and meaningfully involved in those environmental agency actions clarified in this legislation, and to prevent these actions from having adverse implications at the community level on the end. So yes, we strongly support this bill, and we hope the committee will vote in favor. Thank you also to the patron as well.
Stephen Fishbach, please go ahead.
Good afternoon. My name is Steve Fishbach. I'm the litigation director for the Virginia Poverty Law Center, which is the state support center for all the legal aid organizations in Virginia. My organization strongly supports the bill. I was actually one of the drafters of the legislation. This bill, as Senator Hashmi mentioned, builds on last year's Environmental Justice Act by requiring each agency to have a policy on issues related to the environment. It's not a policy for everything. It relates to covered actions related to the environment. The second thing I just wanted to quickly note was that the definition of cumulative impacts is virtually copied word for word from a federal regulation cited at 40 CFR 1508.7. That is a regulation issued by the Council on Environmental Quality and interpreting the National Environmental Policy Act. And there's a definition for cumulative impacts in those regulations. And again, that's the source of that particular definition. It's a well-seasoned definition that didn't just pop out of nowhere. So with that, I'm happy to answer any other questions that the committee has. And again, urge you all to support the bill, and thank you very much for your time.
Beth Creditas, please go ahead.
Hi, thank you. My name's Beth Creditas. I'm a resident of Henrico Senate District 12. I'm also a member of Mothers Out Front. In the late winter of 2019, I learned that 2 gas plants were proposed. One was already fully permitted for the community of Charles City County, Virginia. This is a majority minority rural community. I was appalled when I learned that these gas plants would be a significant source of particulate matter, nitrogen oxides, and over 10 million tons of carbon dioxide equivalent annually. There are significant health risks posed by these projects. And when I began to reach out to residents of Charles City County, calling the pastors of African-American churches there, I discovered that no one had any idea that these projects were even proposed. I tried to imagine what it would feel like to have 2 massive polluting projects proposed in my backyard without my knowledge. And I realized that this would never happen because I live in a majority largely white, middle-class neighborhood. Today, Charles City County residents have to worry about the construction of 2 gas plants, the expansion of a mega landfill in their community, and the prospect of pipelines that would inevitably supply frack gas to those plants. So this is a really good example of how cumulative impact looks to residents. I believe that these projects were cited in Charles City County because of systemic racism. And I believe that this will happen again and again unless we make environmental justice a requirement under Virginia state law. I deeply support this bill. If aspects of Senate Bill 1318 had been required, the devastating experience of Charles City County residents would not have happened, and their rights to information, the notice, involvement, and inclusion would have been protected. So please, I ask you to support Senate Bill 1318. Thank you for your time.
Omar Rosales Cortez.
Good evening, Mr. Chairman, members of the committee. My name is Omar Rosales, and I'm with the Chesapeake Climate Action Network and CCAN Action Fund. Although the Environmental Justice Act made progress last year, the state still lacks the tools necessary to ensure environmental justice is carried out. This bill improves the Environmental Justice Act by 1, clarifying and improving existing policies and language for agency impacts, 2, requiring state agencies to adopt agency-specific environmental justice policies, and 3, codifying the Environmental Justice Interagency Working Group created and approved in last year's budget bill. And it is for these reasons that the CCAN Action Fund supports this bill, SB 1318, and urges for your support as well.
Ashley Crocker, please go ahead.
Hi, my name is Ashley Crocker. I'm the Communications Director for Progress Virginia. I'm here to speak in support of the bill because all of us want to drink clean water, breathe clean air, and work together to mitigate the impacts of climate change. But while we're doing that, we must be sure to center environmental justice at the same time. Environmental policy that doesn't intentionally center equity results in harm, especially for low-income families and people of color. The people who are most impacted by environmental injustice deserve a seat at the table when it comes to making decisions for their own communities. We must incorporate environmental justice policies at all levels of state and local government to give impacted communities a strong voice. So I urge you to vote for this bill. Thank you.
Emily Piontek, please go ahead.
Hi, Senators. Good afternoon. I wanted to thank you for this opportunity today to speak of Senate Bill 1318. My name is Emily Piontek, and I'm here on behalf of Appalachian Voices. Appalachian Voices is a member of the Virginia Environmental Justice Collaborative, and in that role, we've worked closely with Senator Hashmi to develop this important piece of legislation. In my role as field coordinator for Appalachian Voices, I've met with people from across Virginia to discuss issues regarding their local environment. People have consistently raised concerns to me about the process by which state agencies make permitting decisions for polluting facilities like power plants, landfills, and wastewater management sites, particularly when these types of facilities are destined to be situated within environmental justice communities, as those communities are defined by last year's Virginia Environmental Justice Act. Senate Bill 1318 seeks to address these concerns. The EJ Act's policy declaration alone, when coupled with existing public participation requirements, doesn't provide for the fair treatment and meaningful involvement of impacted people as agencies make environmental decisions. This is demonstrated by the persistent environmental injustices related to the siting of polluting facilities or other environmentally hazardous activities in these EJ communities. For this reason, Senate Bill 1318 goes beyond the simple policy declaration by requiring state agencies to develop environmental justice strategies, and then by granting them the authority they need to implement their plans. Again, I'm asking you to support this bill on behalf of impacted people across the state. By building on last year's historic Environmental Justice Act, you have the opportunity to make Virginia a leader for other states to model. Thank you.
Dr. Kathleen Price, please go ahead.
Hello, Chairman and members of the committee. Thank you for allowing me to speak. I'm a physician with the Virginia Clinicians for Climate Action, which is a 400-member health professionals group from across the Commonwealth. And we're concerned about the health impacts of environmental factors, and specifically here with those impacts on people of color and poor communities, vulnerable communities. We know you probably know that there are health impacts from air pollution and toxins, including increased asthma attacks, increased development of asthma, worsening of lung disease, heart attacks and strokes. And these are seen to a higher incidence in the vulnerable communities. So we really need to address this. So we support this bill because it will help protect those communities. Also, a component of the bill is that it asks for increased air quality monitoring. Currently, we don't have enough stations around the state, so we really don't know what's going on in a lot of places. So we need that data so we can better plan in the future to deal with the transportation sector and polluting plants. So we strongly ask you to support it. Thank you very much.
All right.
Christopher Lyon, please go ahead.
Mr. Chairman, members of the committee, Chris Lyon, representing the Virginia League of Conservation Voters, and I'm here today to support SB 13 for the reasons articulated by the patron, the Environmental Justice Collaborative, New Virginia Majority, the Sierra Club, Virginia Poverty Law Center, Progress Virginia, and Mothers Out Front, among many others. We know that decades of systemic discrimination are going to take years of concerted effort by policymakers to fix, and we would like to thank Senator Hashmi for bringing this forward, and for Mr. Chair and the committee for engaging in that work here today.
Thank you.
Narissa Turner, please go ahead.
Mr. Chair, members of the committee, in the sake of time, I'll keep my comments brief. I'm Narissa Turner with the Virginia Conservation Network, and I would just like to echo and uplift the comments made by all of the previous commenters, and I would urge you to support this bill. Thank you.
Thank you.
Finally, Faith Turner, please go ahead. Faith Harris, please unmute yourself.
Okay, thank you. Sorry, you said Turner, so I was a little confused. I am Faith Harris. I am the interim co-director for Virginia Interfaith Power and Light, and we are a people of faith collaborating to grow healthy communities across the state. And so to that end, we support this bill. We have worked with the EJ Collaborative over the course of the last several years to see Virginia adopt bills that will actually make a difference in the lives of the people that we serve. This bill will go a long way in helping to keep communities informed of the projects and the infrastructure, fossil fuel infrastructure that will are slated and planned for their communities, giving them the opportunity to have meaningful input in engagement in the processes, and to be able, and hopefully to be able to convince industries otherwise. I encourage and really ask for the support for this bill this year, and it will go very far in strengthening the bills that were passed last year, the Virginia Environmental Justice Act, and we are in full support along with all of our other collaborative partners.
That completes the public testimony on the bill. Are there any further questions? Anyone has or comments? All right, the floor is open for a motion. And I assume this will be going to finance?
This will also to finance, Mr. Chairman. Second.
All right, we have a motion and a second to report and re-refer to finance. Any further discussion? All right, let's vote on the board.
Senator Vogel, how do you vote?
Can I abstain? I'm so sorry. I just had to present a bill. I'm going to abstain. Thank you.
Stewart votes no by proxy.
Ayes 7, noes 6, 2 abstains.
All right, the bill passes and is reported, will be referred to finance. 7 to 6 to 2 with 2 abstentions. All right. Senator Donovan. Senate Bill 1324.
Thank you, Mr. President. Let me just get to my page real quickly, if I may. Mr. President, this is a bill I am presenting on behalf of the Virginia Commonwealth Chapter of Appraisers. And basically, this seeks to set a statute of limitations for lawsuits against appraisers that's in alignment with all of the other entities that work with mortgages. I would offer an amendment, or is it a substitute? I'll ask staff.
Mr. Chairman, Senator Donovan, it is line amendments, and it should show up on LIS now.
And to speak to the line amendments, essentially when this bill was first composed, it had a limit for discovery of 1 year, as well as a statute of limitations of 5 years. And in the process of collaboration, that 1 year discovery was stricken, and it's just a 5-year for statute of limitations for lawsuits. And I mean, that's really where we get to the issue. This allows small businesses, which have had some strife because there was no statute of limitation for appraisers, real estate appraisers before, to just be able to plan and plan risk. So with that, Mr. President, I will present the bill and be happy to answer any questions.
All right, are there questions of the patron?
When it's appropriate, I've got a motion.
All right, well, if there are no, yeah, I was going to say, we need to adopt the amendments.
Move
Yeah.
to adopt the amendments.
Okay, the line amendments are moved in a second. Any further discussion on that? All in favor say aye.
Aye.
All opposed, no. The line amendments are adopted.
And then I would move to report when
No
appropriate.
further discussion, Senator Evan.
Move to report.
All right. All right. So we have a motion to report. Is there any further discussion? Yes. All right. I didn't know. I think like I did on this one. Was there any on this? Okay.
Scott, would you please go ahead?
Sure. Thank you very much, Mr. Chairman. In the interest of time, I'll be very brief. We thank Senator Donovan for patroning this bill. She did an excellent job of summarizing it. I'll just add that the 5-year statute of limitations that we are trying to create is consistent with the 5-year record-keeping rule that is included in the Uniform Standards of Professional Appraisal Practice, which every licensed and certified appraiser in the Commonwealth is required to follow. And we also are supportive of the amendments that were just adopted to strike the 1-year inside limit on the statute of limitations. And we appreciate the committee's support. Thank you very much.
Nobody else? Okay. That's it on public comment. So we have a motion to report the bill that's been seconded. Any further discussion? All right, let's vote on the board.
Senator Vogel, how do you vote?
Senator Vogel votes aye.
Stewart votes aye by proxy.
Ayes 15, no 0.
All right, I think we have one more bill to take up, and that is Senator Vogel's Bill 1343.
Thank you, Mr. Chair. Hopefully this will go better than the bill I just did for Fauquier in courts. Wait, can you see me?
I said it's good to see you, so.
Oh, it's better to see you. I would give anything to be there with you behind that plexiglass. If I don't get out of this house soon, I'm not sure how things are going to go. So let me just get to this really quickly. Hopefully this is pretty straightforward. I have Senate Bill 1343. This is a FOIA exemption bill. It is it deals with proprietary records and trade secrets in disclosure where we are dealing with carbon sequestration. And we are finding that there is a considerable private investment capital meant to play in this space. And we have a lot of people who are advocating to incentivize participation, but it is this barrier that I think people are aware is an issue. This is not breaking any new ground. This is virtually identical to what the General Assembly passed almost unanimously. I think we only have one no vote against it for solar energy agreements. And so I know that the hour is late and I have a lot of really compelling points that I can make, but perhaps I will let Eldon James, who I know has been waiting in the Zoom room for what I'm sure feels like a week, to speak on this. He and others in Fauquier County, and I think also Secretary Ring may be available to speak to it if it gets any kind of gets wobbly.
All right, are there questions of the patron?
Mr. Chairman, briefly.
Yes, Senator Evans.
Just as Senator Vogel, I'm not as familiar with carbon sequestration agreements. Are those for capturing carbon underground to isolate it, or what are those for?
So I'm gonna let Eldon James, if you'll let me defer to him, let him speak to it and tell you why it's relevant and what it means in Virginia right now and why it's particularly important in my region. So if I can yield my time to him and let him speak to that. Eldon, are you there?
Yes, I am.
Go ahead.
Just want to make sure you can hear me.
Mm-hmm.
Thank you, Senator Vogel, and thank you on behalf of Fauquier County for carrying this. And to try to provide just a tad bit of background that will help with Senator Evans' question. This is based on some work and research done by the Virginia Department of Forestry and the Rappahannock River Basin Commission concerning local forest conservation strategies as a creditable, as an approach to water quality improvement. The work of Department of Forestry and the River Basin Commission led to Chesapeake Bay model in the last change to the model, recognizing forest conservation as a creditable TMDO activity. And so incentivizing private forest land owners to retain and not convert their forest land is a proven water quality strategy, as well as enhancing carbon sequestration. The research further revealed that this incentivization for forest landowners can access considerable private investment capital looking to invest in carbon sequestration through these efforts as an offset to environmental impacts. The research also found that there's a significant interest on the part of forest landowners in entering into these sequestration agreements as another means of income for the forest landowner. However, private institutional capital investors need to invest in projects at a minimum of $50 million. And these are corporations like Shell Oil. Therefore, the individual landowner can't access those markets. Fauquier County's been working with a private broker or an aggregator to bring together enough landowners to gain access to the market. And we're really at the juncture now that for localities to engage these private sector brokers to facilitate these aggregation agreements with landowners and with the private institutional capital investors, their trade secrets have to be protected. Unfortunately, the lack of this business protection has really stalled the effort in Fauquier and stalled their effort to do what they were trying to accomplish some of the Chesapeake Bay TMDL goals. I hope that answers your question, Senator Evans.
Yes, thank you.
Are there any other questions of the patron?
Mr. Chairman?
Yes.
Would you be able to explain to us exactly what carbon sequestration is so that everybody has a general understanding of that?
I can do my best. I'm not a scientist, Senator Boysko, but what it accomplishes is locking up the carbon from the atmosphere, and in so doing, captures it in the forest, in the trees, and it helps in multiple ways. One is it does help with climate change. It also helps because forest land cover is the best land cover for water quality improvement. So if our private forest landowners retain their forest land, we're actually moving to reach Chesapeake Bay goals without spending tax dollars, but instead generating a market that is profitable for the forest landowner. So everybody wins.
Thank you.
May I speak to that, Mr. Chair, for just a moment? I think to elaborate, what we're really talking about when you're talking about carbon sequestration here is that you're using trees and forests actually as the trade-off, as a way to contribute to a better environment, better air quality, address the CO2 issue. And when you say sequestration, to make it a much simpler explanation, it's really talking about using forest land and trees. And in Virginia, this is a relevant statistic. Virginia forests offset almost 20% of our CO2 emissions. So the goal is to protect our forests. And this sequestration agreement that you can enter into is one way to do that. And we're trying to incentivize more people to do it, if that helps.
Senator Vogel, just a quick question. Is this bill basically 3 words on line 262? Is there anything else in the bill?
Nope, that's it. We're trying to do what we did with solar agreements before.
For solar, just to add that.
Yeah, and we're trying to do it here. And it really, I'm not aware of any opposition. I know Secretary Ring and the administration are very much in favor of it, and we're ready to speak if we had a problem when you needed them to speak. But I think this is a step in the right direction, and the goal is to try to incentivize more of these agreements.
Okay. All right. Are there any other questions? All right. Is there anyone from the public to speak? All right. We do have one.
Dan Holmes, please go ahead.
Again, my name is Dan Holmes. I'm speaking on behalf of the Piedmont Environmental Council. We support the legislation before you and any necessary measures to further participation in carbon markets, allowing for the environmental benefits and those that may accrue to landowners that wish to participate or pursue sequestration practices on their property. It is our understanding this legislation protecting proprietary information is needed to accomplish this end, and for that reason, we hope that you'll progress the bill. Thank you for your consideration.
All right, thank you.
Thank you, Dan.
Yes, and that was it in terms
Move to
of
report. Second.
motion to report and a second. Any further discussion or questions? All right, let's vote on the board. I assume this does not need to go to finance. All right.
Senator Vogel, how do you vote?
Senator Vogel absolutely votes aye.
Stewart votes aye by proxy.
Ayes 14, noes 0, 1 abstention.
Okay. All right, thank you. And Senator Zerval has Senate Bill 1384, and he would like that to go by for the day. So if anyone would like to make a motion on that. All right, we have a motion and a second on 1384 going by for the day. All in favor say aye. Aye. All opposed, no. All right, that motion passes. And as far as I know, that clears the calendar? Does that take care of the calendar?
Yes, I believe we voted on them all or passed them all back to them.
All right. All right. Thank you, everybody. Hopefully, we will convene on next Wednesday and get rid of the rest of them. So, thank you. What's that?